Yes.
May I please look at it? For taking an urgent matter method regarding termination of a sexual employee during subsistence of contract. What happened, my lord? He was terminated. Immediately, he filed a representation before the CEO. Why terminated? Because he has raised objection to receive dual salary by the chief
When terminated?
executive on 1610. After that, he filed representation.
So you can wait.
Lordship, what happened? He was asked to appear before the officer for reconsideration of his termination. He was waited. Yesterday, on Saturday, interview advertisement was published for interview tomorrow. If post is filled up, then my God, everything will.
Advertisement is when?
It is on fifth, on third.
On third.
Third. Interview
Third
on
is
fifth.
not third. It is third is a Sunday.
Third on Saturday. Saturday.
Okay.
Second.
And last date, anything. It's walk-in interview or what?
Walk-in interview on tomorrow. That is why I am here. Right. But in regard by 27, little bit of acknowledgement. I have taken the consent of my. Can it be taken of 6? Admission.
On when?
6. 6. Yeah, oblige.
Readings are complete or?
Yes.
What is that?
Yes. But it what? But out. But if that but
So,
I did
can you stay in the dismissal or?
date of type. If it
When is the date it should get as per this court order?
with 7.
When the 7 days is expired?
Yeah.
Right?
That right. Next week or 3.
What is the
After one for the my every promotion stay elected for appointment as the constable of the chair. Sir, wait for the daily the appointment was cancelled because of the duty interpreting period I had with the institute
during training?
due to the intervening period of selection.
Okay. When the matter was filed?
It was filed the year 2022. The affidavit also filed. We have also had counter affidavit after the matter.
When do you want?
It is another matter for promotion.
What is the step? Please tell us. Promotion we understand. Many methods are there.
That is
What is the urgency?
that is
It will
departmental.
be listed. Somebody will say, no, we want time to file everything. Then one method is on. Is it ready for decision?
Not.
Or otherwise it's the order column? The order column. Yes. Why? On the basis of same selection. Please raise your voice or what is the method? No, what is the issue? You have been terminated, you have been transferred, you are not getting
He
promoted.
was earlier he was engaged, but later on he was accepted.
So what is the stage of it?
Ordered.
Order, fine. No problem. Give it for order.
But I think 35 days dated.
Hmm.
Filing the reply, the course of the
You are filing a reply
Yes.
for respondent number.
on behalf of the petitioner,
Reply.
by their
Okay.
May I please observe? Petition for dismissal contempt method.
Just a minute. The learned counsel for the petitioner response and then granted sentence time to fight the reply affidavit to the affidavit includes filed by the private. Yes.
Petition for dismissal contempt method in order.
Not service complete.
Okay, if it is not then
Service is complete.
yes, sir.
Orders.
Sir.
Contempt order.
Lot, I beg for listing of a lot complete. Last bit on lot in the answer part,
What is the state?
state plot state.
Affidavit file. Service is complete.
Not quite.
Mark it in the orders column.
But if similar stuff for other that is the appointment of task control.
Hmm.
The method already similar method already got also the method.
May I please, your lord. My lord, I have explanation item 20 to 25, my lord. In these cases, we are directed to file, my lord, supplementary affidavit. My lord, I pray for further 2 weeks time to file.
Wait.
Epic.
Yes.
I think to mention item report for
Withdraw.
But-
With liberty, but
But-
not what without liberty.
with liberty.
Why contempt? Why you want a liberty? It is completed, complied with,
Not okay.
then why you want to withdraw?
Not that there is a
Okay. Learned counsel for the petitioner submits that there are defects in filing the petition. Accordingly, says that he may be allowed to withdraw the present contempt petition and refile the same with a liberty to refile the same after curing the defects. Full stop. Prayer is allowed. Accordingly, this contempt petition stands closed with liberty and so that's not contempt. Speaker is not working or what?
matter pertaining to application of subject grade 4 to grade 3.
Hmm.
The alternative is the sitting to be
Leave name mark in the orders column. We'll see. Orders column. Yes.
I apply for listing of the case WC2921 by 23 for question of impugned disciplinary action. The case was last heard on 26/5/23.
It's admission stage or hearing stage?
Motion.
Motion. Okay, motion.
I
Fine.
want it to,
Yes.
Really, 385. I take 2 weeks.
I'm not getting it.
I take
Item number? Where will I pass the order that you have withdrawn a bail application? First of all. Second, this bench is not taking a bail matter. Sir,
Then okay.
Then you have to mention before that,
On first, what happened? In our bench.
It's 21.
Your thinking will not do. You'll have to say 21 or 22 or 23. Huh? How can you withdraw? We say that we'll dispute those methods, NDPS.
Document.
They've already passed order. I think we'll sign. In fact, might have signed also. How can you withdraw a matter after matter is hard and said that it's kept for order, passing order? Huh?
LCR.
If LCS call for it will on that day you file an application mention memo
mention memo
for withdrawal.
not that.
How can you pass an order like this? Yes.
May it resolve.
Why it listed here?
Second time, 55 days. So statutory period 60 days. 53 days. 54 days today. Counting मतलब?
Considering the period of detention.
Region Kamrup.
Citizen Kamrup.
Hello.
Next is the dot.
Yes.
Petitioner initiated audit an advertisement of 2009. Appeared with
This litigation should end here today. Okay, proceed. Proceed. Then what happened?
there's an order of this honorable court
What is that order?
to consider the case as per.
They have considered and they said that you are not at that.
No, they are considering my case. Just a second. The date of advertisement which is mentioned in that new order. I think there is miscommunication because we are saying that our advertisement of 2009 and they are referring to an advertisement of 8 to 2010 lot. I think there is some miscommunication. Page number 76. Last paragraph.
So you are disqualified.
Perfect. Okay. The entire process is entire challenge is that pursuant to advertisement dated 2009. Which we
Just remind yourself we are in 2023.
is clear.
We even do not know whether you can even hold a gun. Yes. Next. Take your seat. Mr. Dhar, take your seat. Yes.
Okay. And the input order, they're saying I am upgrade qualified. Important to the address because I think the names, the dates are different. That is why there's some miscommunication. Maybe. Page number 7.
You have seen that, page 76.
Last paragraph.
Now, what do you want here in this litigation? What is your prayer?
Our
Be confident of your case.
yes,
Yes.
our case may be considered.
Who will consider? That order has already been passed.
We will
Hard. MS Kanun ko learned counsel for the petitioner also hard. So. The
Mr. R.
hard. The present writ petition is filed assailing an order dated 16th of September 2029 passed by the Additional Director General of Police within bracket A, Assam, Guwahati, in pursuance of an order dated passed by this court or in pursuance of an order dated
So far the subsistence allowance is concerned, he has been placed under suspension on 17/6/2020. Replies given. My lord, yes, my lord, only lordship petitioner has been registered to submit and posted in the Hilton Lord. Although his initial appointment was in the directorate. Now the grievances, my lord, now the grievances is there. Although the petitioner was placed, no lordship, that is the problem, lordship. That has not been fixed.
Lordship, need some time to take instruction, Lordship. Lord. Yes, yes.
T11/20.
The next. T Thakuria, Lord. Obliged. Obliged.
Lordship, in this case, Lordship, the petitioners are the family members of disabled persons as per the prescription of the Assam Public Service Granted Appointment Rules 1999. And accordingly, they have been issued certificates by the Lordship Additional District Magistrate Lordship Norwalk. Lordship. At this stage, Lordship, now state level commission for recruitment commission for class 3 posts and state level commission for class 4 posts. Both the commissions have published advertisement for recruitment of 7,600 posts in the case of
What is the last date?
last date is 15 December 2023.
Now your grievance is that it's a online portal,
Yes,
and there is no scope for you to intimate or inform that we are entitled preference under this act.
Yes, Lordship, one more thing is Lordship that the writ petitioners earlier occasion approached the Honorable Court, and the Honorable Court has observed that your Lordship will find at page number 27 that the respondent would have to determine whether any quota is reserved for filling up the said post by way of the Rule 1999 and rules. The respondent would also have to verify whether the petitioner has applied under the quota reserved under the 1999 rule. One thing is that, Lordship, the second observation is that before parting with the record, it would be appropriate to mention herein that if the recruitment process is conducted online, then the respondent authorities are required to provide a window in the website to enable the petitioner and other similar situated persons to upload their document to show there is eligibility to be considered under the rule.
Now,
and there is now in this present advertisement, Lordship, it is clearly seen that there is no scope given to the
yes, Mr. They are limited period. That at least you should know that whether you are entitled, because preference, earlier judgment says that preference will mean you must compete in the selection process. But suppose there are two persons are equally situated on merit, you will get a preference.
Lordship,
Now-
I'm representing respondent number 2 and 3.
Who issued the advertisement?
It to Lordship, respondent number 2.
We
Lordship,
want
two
to
and
have
three,
an
Lordship.
instruction from the authority who has issued the
2 and
advertisement.
3, Lordship. Respondent number 2, secretary.
Lordship, I came to know about the case only from my
Okay,
friend.
okay, no issue. That is not.
May give me some time to take
Wednesday?
the instruction.
You just have, what is
Yes.
the last date? 15 December.
15 December.
So we are taking this matter
Friday, Lordship.
next Monday. Next Monday, you obtain the answer.
Yes, sir.
The limited grievance raised in the writ petition is that
Friday.
Huh?
Friday. It's possible.
Friday. Okay. The limited grievance raised in the present petition is that the petitioners are entitled for preferential treatment under
Assam Public Service. Differential
Assam Public
appointment,
Service within bracket
Differential appointment,
preferential appointment bracket close rules
19.
1999. However, there is no scope of making such disclosure in the online advertisement dated
30.
advertisement
October.
dated
31 October
31/10/2023 for filling up of 31/2023 issued by the respondent number 2 and 3 for filling up of 7,006 numbers of vacant class 3 posts under different establishments. Full stop.
and also 5,000 posts.
And
class
another 5,000 posts
class 4
class 4
Under-
another 5,000 class 4 vacant posts. Full stop. For দুটাই করবে class 3 class 4 to have like. Full stop. It's a P. Chaudhary, learned standing counsel for the
Lordship, state level recruitment commission for grade 3 and grade 4.
state level recommend for respondent number
2 and 3.
2 and 3. The standing counsel representing respondent number 2 and 3 submits that he may be allowed some time to obtain instruction in this regard. But the prayer is allowed. List this matter on Friday. Divided.
Lordship,
I live.
extra copies I have not.
Right now,
Extra copies of the petition. 2 extra copies.
And Lordship, our name.
Okay, 2 extra copies of the petition be furnished to Mr. P. Chaudhary, learned standing counsel. Full stop. Registry to list this matter showing the name of Mr. B. Chaudhary as standing counsel to state level committee in the court list.
I live.
Yes.
In this matter, proceeding was initiated against the petitioner in the year 2018. Subsequently,
Yes, he says that you can take a call. Where is the question of press inquiry? You can take a call. You can differ with the opinion of the inquiry of authority, and you can have your own understanding. That can appeal can be preferred, but how can you direct the press inquiry? Why should you face the inquiry? Third, learned counsel for the petitioner. Mr. Spencer, give the names of and Spencer. The present writ petition is filed assailing. No, no. We'll issue notice and we'll say that you should not proceed with a fresh inquiry. We are not saying anything what you can do, you know it. We are saying it as no fresh inquiry. Come on. Filed an application. Assailing a notification dated 12/1/2023 initiating de novo inquiry against the petitioner. The case of the petitioner is that pursuant to an earlier inquiry, the petitioner was exonerated by the inquiry officer, and without taking a call on such finding, his employer has directed a fresh inquiry on the same charges, which is not permissible under law. Full stop. This matter needs further consideration. Full stop. This court is also of the prima facie view that the employer shall not be within its right to initiate a fresh inquiry on the basis of charges charges framed only on the ground that the inquiry officer appointed earlier has exonerated the delinquent delinquent employee. Full stop.
Committed irregularity.
Huh?
Committed
Whatsoever committed irregularity. But you were exonerated by the inquiry committee.
nothing reflected, but they take the plea that inquiry will
Did you have an inquiry report?
Lot.
Where is that?
Lot.
What is the finding of the inquiry?
inquiry will page 46.
What is the finding?
Inquiry officer said that I had some role in execution of the work. Page 46.
No. What is his conclusion?
Conclusion
Page
was
46.
lot. Conclusion page 51.
Last line, last line.
Where is your chart?
Lot page 38. Page
Where is
38.
the reference to this inquiry? Where is your search memo?
Page 38. Statement of allegation and charge of supply.
Page 30.
8. Annex 3.
Part number 1.
Statement of allegation.
Page 41.
Now, what is the findings on the each of the charges?
No independent findings. No independent findings. They said that Lordship, page 51, the chief engineer may recheck the design of the structure. I had no role to play in design.
No, we cannot decide that.
Lordship. And then, Lordship, I replied to this very Lordship, page 52. After my reply, they initiated it. Page 52 is my each chart.
How can it be treated as a departmental inquiry at all? It was a fact-finding inquiry.
Yes.
Departmental inquiry not yet initiated. These are site visit and report. This is not an inquiry. Huh? Did you appear before the inquiry officer?
Earlier, I appeared.
Have you laid evidence?
Evidence is not acceptable.
Then how can you say it to be the inquiry? Notice.
Notice.
Not prime evidence. Your whole case is structured on a different footing. A case where the inquiry is given, charges are, inquiry officer gives a report saying the agreeing or disagree. Suppose the inquiry officer exonerates you. They can very well take on record the evidence and all, apply their own mind and disagree with you and come to their own conclusion. It's not that it is binding. But here that findings is not there. Why will they be barred from?
I have alternate prayer also to conclude the logical conclusion.
So that we can dispose it of.
Lordship, I have
Second inquiry.
I have a representation also, Lordship, because due to this planned period, Lordship, my
Yes,
junior,
the
Lordship,
limited prayer raised in this petition is that the inquiry, de novo inquiry, they use the word de novo.
yes,
That is not the de novo
Yes.
inquiry. Foreign language should not be used everywhere.
Yes.
This is not a de novo inquiry. This was a fact-finding inquiry.
Yes.
Now they, on the basis of that fact-finding inquiry, now they will
Yes.
start the departmental proceeding.
Yes.
Yes.
Isn't it?
Lordship, term
term, forget about the term.
Lordship may issue a notice at this.
Notice.
Lord,
Okay.
pendency may not be for conclusion.
Application, assailing and assailing, প্রথমে বললো de novo to enter to enter. Issue notice returnable after 4 weeks. Full stop. Pendency of the present proceeding shall not be a bar for the department to continue with the proposed departmental proceeding,
Yes.
de novo proceeding, de novo proceeding,
And logical.
de novo proceeding, and we will not say for then we can dispose it of de novo.
Oblige.
In as much as the petitioner is also agreeable that the de novo proceeding should be completed at the earliest and a logical conclusion of the same should be made.
As junior officer, one more time.
As the it is also concern of the petitioner that due to pendency of the departmental proceeding, his case for promotion is not being considered.
Oblige.
You do it, complete it.
Lord.
You will participate.
Lord.
We could have disposed it of this petition. If we give up the first part, we can dispose it of. Do it. You have an instruction you are taking day after tomorrow. Within what period you can do, we'll provide that you will not take unnecessary adjournment.
And but I have a representation of the disposable to what?
Huh? On the prayer of the learned counsel for the department, list this matter on Wednesday. You have the instruction.
Oblige.
What is this? I could not understand anything.
Okay, just
You applied for Kazi.
okay.
Now,
Interview, they have conducted both
interview
Interview
for
or a-
empanelment or interview for appointment.
empanelment.
Empanelment.
But-
What is the procedure?
That procedure is as per lordship rule. That time, like, I have mentioned it. That rule lordship. Number two.
Just tell us. Suppose they need a Kazi.
Okay.
They will seek an application. People who are having that qualification under the some Muslim Marriages and Divorce Act, they will apply.
Okay.
Now, suppose who will determine that will empanel so much Kazis?
Lordship,
Because these are not a government service.
no,
This is a recognition only that
On
you
license.
can
Only license has been given.
administer a marriage. That's much.
just I
That's
am coming lordship.
Hmm.
Deputy commissioner required to call only applications lordship, nomination. But here in this case, he prepared a panel
Hmm.
of maintaining seriality, and after that, written one letter lordship to the permanent committee. Where is the permanent? There is a permanent committee. They should have decided from the name which panel name, but no question of any merit list is from the deputy commissioner. Deputy commissioner has prepared the complete merit list by series mentioning number, marks, seriality, everything. But the law says only nomination from the deputy.
no. What is the nomination on what basis?
No.
There must be some criteria. Deputy commissioner love this space, then
Hmm.
and this space is not good.
No,
There must be some criteria.
lordship,
What is the
lordship, I am coming,
criteria?
lordship.
Huh?
The rule says that the district register nomination shall be submitted to the inspector general of registration to be placed before the permanent committee.
No,
Yes.
that part we have understood. That deputy commissioner will nominate. That these are the persons. What is the criteria for deputy commissioner to nominate?
Nomination, as per their advertisement, they have said up to MM level educational qualification.
No, forget about advertisement. Nothing in the
That lordship, yes, coming. I am also lordship.
that is vital. What the
Lordship.
rule says that
Who
this
may
is
be
the
nominated?
prescribed
Who may be nominated? Rule 4.
No, not
Yes.
forget about who for the time being.
Sir.
That who will nominate, forget. What is the qualification for nomination?
Is required for FM lordship.
FM. Okay.
Sir.
Okay.
FM.
So deputy commissioner,
FMM.
FMM, deputy commissioner will call interested persons that we want to nominate Kazi. Please give your application. Now you give the application. Then deputy commissioner will send it to
IGR.
IGR,
IGR.
Lordship,
Then IGR will
will decide from
Well,
that.
IGR will not, but a permanent committee will
Decide.
There is a committee.
and then IGR will issue the final order. So committee will decide. Now, what is deputy commissioner is to send the application, all the application.
All that.
So now here what he has done, he has made a select committee and only 7 names have been sent.
Even then,
He is not the authority.
Lordship.
He is the post office only.
Lordship.
Is not it?
Lordship.
So that is what I understood. He is the
Lordship,
post
Lordship,
office.
correct,
That he will call, they will give the copy,
Lordship.
whether is having MM or
Lordship.
FM, it will be decided by the
By the
permanent committee.
No,
Lordship,
even
my
then, my lord,
responsibility.
deputy commissioner has the right duty to my lord to verify the document whether he is eligible qualification is have the no or no.
What is the deputy commissioner role in the rules was? What the role attributed to the deputy commissioner?
Rotima, kindly see the form of application rule 3.
Form of application rule 3.
Lordship, good.
Yes, yes.
Good one. Yes, yes, up.
He will have to give a certification if he is satisfied that he is having a good character and his certificate.
He's only forwarded the
He is a forwarding authority.
Lordship.
Now, what if in this case have been done to us?
Page 35 is the Lordship, the comparative statement academic qualification. Then page 36 is the merit list, Lordship.
34 is the my lord, the forwarding.
And 34 is the forwarding. Page 36, Lordship, all the marks and position, first, second, third, fourth, fifth, sixth, seventh.
What is this interview for? What is the advertisement?
Lordship, advertisement page, Lordship, advertisement page 32, Lordship.
Any number that this area will give this number of
Lordship, my lord, there is only one, my lord, the person can be appointed, but given the license to my lord, one police station, jurisdiction of the one police station.
one police.
One. There are my lord, two can be given. One is Suni, one is my lord, here.
Yeah.
And he have the jurisdiction only the under that police station.
So this is so far relating to inhabitant of Hailakandi police station.
Police station.
Yes. Advertisement itself is a mistake.
That about Lordship, page 55, the deputy commissioner has recommended one name, Lordship, to appoint. Page 55, annexure 8, Lordship. Second panel list held by name list.
Art. Mr. K. Now, what kind of order you want today?
Lordship, at this stage, may I put your all respect, Lordship? Since I completed other respondent, otherwise I would say that let the entire matter may be deferred to the permanent committee to decide, select from the entire.
My lord, already the matter has been, my lord, submitted before the my lord, that idea. My lord, as part of my lord, the constitution of the my lord, the permanent committee, their matter will be my lord placed before the.
But his name is not sent.
His name is also.
If your name is sent, They will
it is-
decide.
My lord, it is the only,
Without
my lord, that,
influencing the reference of the deputy commissioner.
my lord, deputy
No, no,
commissioner reference, my lord, will
No,
not
not
be, my lord.
reference, that is the panel, that is. which
No,
he
my
has
lord,
recommended.
the permanent committee will decide. They
decide.
will take the decision by
I
the
have no
permanent
objection,
committee.
Lordship, permanent committee will decide as per
As per
all
law,
this
my lord,
after
that-
hearing.
Art. Mr. K.A. Majumdar,
But-
learned counsel for the petitioner, and Mr. Hendik, learned standing counsel for revenue.
1, 2, and 3, lord.
1, 2, and 3, and Mr. Sutia for
4 and 5.
4 and 5. As agreed to by the learned counsel for the parties, the present petition is taken up for final disposal at the motion session. The grievance of the petitioner is that the Deputy Commissioner Hailakandi has sent a panel of names for nomination as what do you call
MMR and Kazi.
MMR,
for nomination of MMR and
And
Kazis under Assam Muslim Marriages and Divorces Registration Rules 1935.
35.
According to Mr. Majumdar, in terms of Rule 2 and 3 of the aforesaid Rules 1935, the Deputy Commissioner's duty is to send the name after proper verification to the permanent committee,
The idea, lord.
the Inspector General of Registration,
respondent number 30.
and thereafter the Inspector General Registration is to consider such applications and take a final call on this application. Full stop. The apprehension of the petitioner is that while sending the name to the IGR, the Deputy Commissioner Hailakandi has prepared a list on merit giving different marks under different heads, and according to Mr. Majumdar, such course of action is not permitted. Per contra, Mr. Hendik submits that the defect in sending the names to the IGR shall have no effect, sent by the Deputy Commissioner shall have no effect upon the IGR, inasmuch as the IGR will take a final call on the names already sent on the basis of Assam Muslim Marriage and Divorces Registration to 1935, and therefore the present writ petition is filed only on the basis of apprehension and without there being any cause of action. Full stop. Consider the
I have asked it.
Yes.
Page 55, Lordship, one name is already recommended.
I already been, my lord, submitted, my lord, it will not be in my lord.
okay. However, Mr. Majumdar, referring to the page
Page 55,
page 55,
Annexure 8, page 55.
page 55 submits that the district commissioner cum district register has already recommended a name of Kazi, name of Kazi. Name of Kazi.
Lord, this is stand for a temporary arrest, not a permanent.
No.
Okay, anyway, we are clarifying it. However, in view of the submission of Mr. Handy, as well as in terms of the rules 1935, the Deputy Commissioner, District Register is having a role under Rule 2 is to send the nomination along with the documents required under Rule 3, and the final call is to be taken by the IGR in terms of Rule 4. That being the position, this court is in agreement with Mr. Handik that the entire matter shall be taken on merit of the case of the individual persons in terms of the rules 1995, not on the basis of the recommendation made by the Deputy Commissioner, inasmuch as the aforesaid rule has not empowered the Commissioner to prepare a list on merit.
As per rule 6, Lordship, the specific element of
Actually, page 35 is not a merit.
Not a merit. Comparative statement. So we have sent it. That's why we will not intercept.
6 is specific to my Lord written. Lord, this list may not be my Lord. List can be disapproved by the permanent committee.
In fact, Rule 6 empowers the permanent committee even to reject the recommendations or nominations sent by
District register.
district register. In view of the aforesaid scheme of the Rules 1935, this court is of the view that the present petition is premature and we cannot anticipate that the IGR or the permanent committee shall only go by the nominations of the Deputy Commissioner and not by its own merit in terms of rule in terms of the rules 1935, more particularly rule 4, 5 and 6, na? 4 and 6. Accordingly, with the opposite observation, these petitions can suppose. However, liberty shall always be with the petitioner if he is aggrieved by any action of the IGR or the permanent.
I only limited prayer is that the IGR may be sorted out because the place is suffering since 2000.
No, we have clarified. We cannot say that do it. There is a power to not even give. Then can we say no, you do it?
No, Lordship, that time.
No, we are not giving anything, any time.
Only
It's a
just
premature
observation is
treatment.
that because the area is suffering for lack
Even
of time.
even in Lordship,
This is a premature petition.
Lordship may kind of given a direction to the Malad that idea.
Idea.
Malad he have to Malad some people of this Malad that area they are suffering.
Okay.
So temporary arrangement can be made by the Malad idea. Lordship it can be given.
No, we are not even going to that. If he demands things that is necessary, we will do it.
Only within short while because people as my learned friend.
No, we are not saying anything beyond that. What is before us, we will decide
Lordship,
that
Lordship,
only.
please.
Yes.
Dismissal from service, my lord, and the appeal has been pending since 8/6/2021. And thereafter, my lord, that criminal trial, my lord, judgment comes in 23/6/2023, which we have submitted to the appellate authority, my lord. This may be disposed of with a direction, my lord, within a specific time. This appeal may be disposed of taking into account the judgment of the criminal court.
We will not say what you will take into account. We will say that matter is pending. You decide it.
Yes.
Why is you are forcing people to file writ petition? You
What we will
do this, huh?
Limited prayer, my lord, that judgment, my lord, of the criminal court.
We cannot comment anything on that.
If
We'll just say that
we have submitted the judgment.
The third Mr. KPL and also Mr.
The
Upamanyu for all the response.
Yes, sir.
The petitioner was prosecuted in terms of pursuant to an FIR being FIR registered as Tinsukia police case number 1117/14 under section 7 of the Prevention of Corruption Act 1988. However, by an order dated, where is that order?
23/6/2023.
20 the
Place 140.
prosecuted under suspension. The investigating authority, after completion of the investigation, submitted charge sheet and trial was completed. You are
The trial
discharged or
completed,
is
my-
discharged or acquittal?
Acquittal.
Acquittal. Full stop. Subsequently, uh, subsequently, special case number 11/2021 one was registered, and after the trial, learned special judge Assam by its judgment and order dated 23/6/2023 acquitted the petition. Acquitted the petition. Full stop. During the pendency of the aforesaid criminal proceeding, a departmental proceeding was initiated against the petitioner on the same set of facts, and finally, by an order dated 15/5/2021, the petitioner was dismissed from service. Dismissed from service pursuant to the aforesaid departmental proceeding. Being aggrieved, the petitioner has in the meantime preferred an appeal before the competent authority under Assam Services Discipline and Appeal Rule 1964. The limited grievance of the petitioner is that the appeal has not yet been decided, and that that the fact of his acquittal in the case should also be considered by the learned appellate authority. Full stop. That aforesaid being the limited prayer on the part of the petitioner, the Mr. Upamanyu, learned standing counsel, has not objected to such prayer. Full stop. This court is also of the opinion that the petitioner shall have a right to a speedy completion of the appeal. Full stop. Accordingly, it is directed that the appellate authority shall conclude the appeal, being appeal number anything. Conclude the departmental appeal within conclude the departmental appeal preferred by the petitioner within a period of
60 days.
Within a period of 60 days. Within a period of 60 days from the date of furnishing a certified copy of this order. It is also made clear that the appellate authority may take note of the order of acquittal and apply its own mind to the facts of the case and pass an order in this regard. However, while parting with the record, it is also made clear that this court has not opined anything on the merit of the appeal or the claim of the petitioner that he is entitled for exoneration in view of his acquittal. The appellate authority to apply its own mind.
Highly obliged.
Dispose of.
Issued, Lordship, and Supreme Court guidelines are there, Lordship. A simultaneous proceeding can be run, Lordship.
Yes.
I have to submit it. Put your two. Proceeding on the basis of that, with that sufficient for personal hurts and private.
Have you filed reply?
Yes, sir. First proposed reply. Page 27.
What is the
second proposed notice? They did not reply. It is given on 20.
What are these?
The same issue here.
How do you know that these are the same fact?
Same fact that criminal case and
These are decided at what stage?
criminal case is pending, Lord.
The criminal case is you are decided.
Pending, Lord. Not decided.
Not decided.
Not decided.
How can that be?
Not. Pending. Pending. Departmental pending. Lord. Premature.
Which one? Okay, so after that. Which judgment says that two parallel proceedings cannot run? So as that judgment.
First one, your Lordship, and
Rajkumar Lal. What is the ratio? Tell us.
8 years.
Hmm.
Propose the respondents to continue the proceed with the department inquiry without
Just a minute. Paragraph
8 years.
Where is the Supreme Court judgment?
Supreme Court judgment, Your Lordship. Captain Ample Attorney, Your Lordship. Bharat Court Mines. Paragraph 22.
No, that 2021 judgment is you were discharged on the same facts, isn't it? Omik Kadu, 2021 PGLT. Here the person was discharged from criminal charges. So since the charges are on the basis of same material, proceeding was set aside, isn't it? So what is the facts in that case? In your case, already you are discharged or what?
No.
So in this case, you are already discharged in the criminal case. Taking note of the fact that similar proceedings, then departmental proceeding was set aside, isn't it? In comic Kadu. Is it not? Yes or no? Yes. So this is not having no applicability. What about state of Arunachal Pradesh? So here is the honorable acquittal. In 1999, you read that 1999 judgment. Continuance of criminal proceeding. The scope of these two proceedings is different and they can be continued independently.
Same set.
That finding will have to be there.
Pending lot, criminal cases, pending lot.
And in Supreme Court's 1999 3 SCC, already acquittal was granted. The person was acquitted. So therefore, Supreme Court says that yes, two proceedings can run, but when once is already acquitted, same set of facts. So therefore, subsequent departmental proceeding could not be continued. So you see, these are the judgments. Your judgment that you are relying on. So relying in this judgment, 1999 3 SCC 67, now we are dismissing it. That's different fact. Hmm?
22. If the department proceeding a criminal case are based on identical and similar set of facts, thus in criminal case against delinquent employees in a grave nature, for petition of law and fact, should be able to say the department proceeding from
Kindly come to paragraph 13 of Supreme Court judgment. Paragraph 13, read paragraph 13
as we shall
of M. Paul Anthony. Paul Anthony's judgment. Read loudly.
we shall presently say there is a
Consensus, slowly go. There is a consensus of
judicial opinion among the High Court positions which do not intend to refer to in this case and the various pronouncements of this court which shall be obviously referred to on the basic principle that proceedings in a criminal case and the defense proceeding can proceed simultaneously with a little exception. As we understand, the basis for this proposition is that a proceeding in a criminal case and defense proceeding operate in the distinct and different jurisdictional areas. Whereas in the department proceeding, where a charge relating to misconduct is being investigated, the factors operating in the mind of the disciplinary authority may be many, such as enforcement of plan or inspect the level of integrity of the delinquent or other stuff. The standard of the proof record in those proceedings also different than that record in a criminal case. But in the department proceeding, the standard of proof is one of the three ponderance of the prohibition in a criminal case. That has to be proved by the prosecution beyond reasonable doubt. The little exception may be where the departmental proceeding and the criminal case are based on the same set of facts. The evidence in both the proceedings is common without that being in various.
So, how will you know that it is variance or not? We'll have to appreciate the evidences in both the cases. Nowhere there is evidence has started.
That's so good. Department proceeding not.
How do you come to a conclusion that this is the evidence relied upon? This is the departmental proceeding evidence relied upon? Nothing is there.
It is there.
Where is that source?
Propose notice is heard.
Why don't you file the reply to the Sokos notice and raise this point?
As Sokos reply, they have
The second Sokos did not reply.
you already their findings, you already second source reply. The answer is that you already finding. Second Sokos notice start to page 33.
Where is, please show me the this order.
Page 33 you already finding. That we already
Where is the search memo? Memorandum of charges.
Page 26. Mitigation.
Huh?
Page 26.
Page
26. Statement of allegation.
where is the charges? Huh?
Department not very rare.
Huh?
First Sokos notice. Statement of allegation. That I want to gross misconduct that that's the Nidation that I want to gross misconduct.
Where is the search sheet? In criminal case.
That is not
Then how do you say that this is the evidence in search sheet?
in the convenient proceeding you already there is
No, no. Suppose we agree your concept that yes, is when the materials are absolutely same, two proceedings should not be allowed to proceed. Now, what are the charges and what are the materials that they are relying on in the search sheet? When search sheet is not filed, how can we come to a conclusion that both are same?
the piece of that
FIR.
FIR.
FIR is not a gospel proof.
Yes, not FIR. But when they initiate the criminal case, the different proceeded so far. And you already say 33.
No, no. What is your case? Your case is two proceedings cannot simultaneously proceed. Okay? The judgment you have relied on says that both can proceed with a little exception that when both sets of materials are same. Now, how do you know that search sheet, these are the materials, these are the witnesses? In that case, all witnesses are same in both the cases. All exhibits are same in both the cases. Now, how do you know that in this case, they are same?
Case, but correct.
If I am correct, I am dismissing it or you will withdraw it. Moment I dismiss, your whole future is gone.
They have they have informant and rather also coming to proceed. They have given a view.
Oh, we'll come to that. You first answer the question. To say that these both are equal, what are the materials in criminal proceeding? Only FIR.
Only
Then only FIR can we go? If FIR is a then
that FIR is no related to the current FIR is not able to this. The basis of that FIR department has
so only on the FIR, since FIR also related to same allegation, so therefore your proceeding cannot be permitted. Option is dismissal or withdrawal at appropriate stage. Dismissal or withdrawal? Huh? apply your mind. The judgment you are relying on itself is same set of evidence. Facts will have to see. Same set, they want in that judgment specifically Supreme Court says that they want to prove both the cases by same set of evidence, same set of documents. Where is that in your case? If that is not there, how can we pass this up? Learned counsel for the petitioner press that he may be allowed to withdraw this present application and participate in the departmental proceeding or proceeding raising all his objections. Where is the he also further submits that he may be granted liberty to file this the liberty to raise a similar issue if so advised. Prayer is allowed according to clause between
This case, my lord, the petitioner was terminated by the IOC. The ground that the caste certificate is fake. And against which the earlier the petitioner filed a petition was but thereafter I have filed a petition.
What is your ground?
Now, my lord, my ground is that earlier I had applied for a certificate when I was a minor. And now they are saying that the certificate, the serial number was not, there's no serial number 324. But when I had applied for the RTI, they have not furnished the to whom this caste certificate was granted.
Heard Mr. F. found learned counsel for the petitioner. Who is deputy SDI for which department?
Petroleum and natural gas.
IOC.
IOC notice to go to IOC.
Notice is to go to HN. You have who are the respondents?
Central government would be one.
The
Only one.
present petition is filed challenging an order of termination dated 8/7/2022 issued by the respondent number 4. In as much as the other challenges are ordered dated 23/5/2022, 25/5/2022, and 28/11/2022, and 9/12/2022 issued by the chairman SC Development Board Saudia and ADC in charge Saudia subdivision, whereby the certificate schedule ka certificate SC certificate issued to the petitioner was declared to be a fake one. According to 8/7/2022 termination order of termination board the further issue notice returnable after 4 weeks. Mr. Sutia accepts notice to
5, 6, 7, 8.
he accepts notice on behalf of respondent number 5, 6, 7, and 8. The petitioner to take steps upon respondent number 1 through the office of the DSGI. The petitioner to take steps for issuance of notice upon respondent number 2, 3, 4, and 2, 3, and 4 to register both as well as to usual process within a period of 5 days. As the respondent number 1, 5, 6, 7, and 8 are duly represented, no formal notice need be issued. However, extra copies of the report.
Okay.
Yes. Yes.
But this matter regarding compulsory department, TLC recommended my lord, but SLC had not.
When your father died?
This my lord on medical ground, my lord, he retired.
No, when died? I have not asked anything, any ground. I have asked when.
My lord, this is not regarding death, my lord.
I understand that is a that regarding retirement on health condition.
Yes.
What is the purpose of retirement on health condition?
My lord,
Giving appointment.
because my lord, was my lord, certificate my lord, page 12. That medical board page, my lord,
Yes.
page 12, my lord. Orthopedic and psychiatry. My lord, state that subsequently he also died 99.
He was retired, compulsorily retired or what?
My lord, he was declared not medically fit to continue.
Where is that?
The medical board examined Sri Asaduddin Batuya and took a opinion of orthopedic and psychiatrist specialist
Okay, not
and
fit to
concludes
continue in his
that,
job. Where is the subsequent order thereafter?
my lord, thereafter, my lord, he submitted one application, my lord, for compensation.
No, we'll come to that. This man was asked that he is not fit to continue in the job. Now, whether it was in reference to somebody else of your department or it's on his own.
So, my lord, subsequently, my lord, this procedure is, my lord, finalized in trust because, my lord, this statement.
Where is that?
This order I am not an expert, but this forwarding letter I am an expert, page 51, regarding compensation.
No. Your compassionate appointment will come when your father's retirement is on the basis of his medical ground. Where is that?
I am not. Otherwise, my lord, maybe this to my lord, page 21, that my lord, this application for compensation appointment was forwarded. This order is also there, my lord, but I am not. And TLC also recommended.
Lordship, apart from this, Lordship,
No,
PLC
we
considered Lordship on 6, 12, 14 Lordship. After 9 years, they have approached the court, Lordship.
Yes, what you say?
Several decisions are there, Lordship.
What you say?
That Lordship, that
What you say? Hmm?
first of all, Lordship, it is not matter of right, Lordship. Secondly, Lordship, the compensation appointment can be done, Lordship, on the basis of the financial condition of the person, Lordship. After the date of
Now,
decease.
Mr. Borbia, show us the under what provision you can be appointed.
My lord, I have, my lord, annexed document.
Hmm?
This, my lord, and High Court order is also there, my lord. Initially, I approached, my lord.
No, tell us.
My lord, referring this rule, my lord, High Court passed the order.
Where is that?
My lord, from page, my lord, 24, starting, my lord, and relevant, my lord, further, my lord, page 27.
Ah. Where is that?
Page, my lord, starting from, my lord, page 24, my lord, and, my lord, operative part, my lord, page 27, last paragraph. Then TLC, my lord, recommended, my lord,
When?
given further, my lord, page 29,
When?
and then, my lord, page
When?
30. My lord,
When?
this is, my lord, 2014.
And what about SLC?
SLC, my lord, they have forwarded, but they have not taken it.
What are you doing now?
My lord, some communication, my lord, is
And what
there.
are you doing now?
Till, my lord,
Huh?
17,
Are you
17, 18,
married? Married? Are you married? First question. What are you doing now?
Oh, yes, my lord. That, my lord, this now, my lord, check, my lord, yes, not
It is a vital question for competition and therefore. Married
very much.
with family.
Father.
Yes.
My lord, till, my lord, 2018, my lord, communication, my
It
lord.
is not a regular mode of living. You have survived, you are married. If your wife files tomorrow
But, my lord,
125, you will have to
thing,
pay her.
but there, see, my lord, the part, my lord, so far, my lord, it is, my lord, fundamental right, my lord. That's not my understanding.
Which is fundamental, right?
My lord, this procedure, my lord, because there is a, my lord, statutory procedure
Hmm.
prescribed, my lord. But they have not concluded that part, my lord. Ultimately, well, any appointment, I have no right, my lord. But the procedure prescribed is, my lord, fundamental
We'll
right.
say that we'll say that it is your argument and therefore delay and latches.
Detail that is, my lord, I have annexed, my lord, recently one order passed, my lord. It is 1995 matter. Where that, my lord, this honorable court, my lord, considered, my
Is
lord,
there any ratio that in it should be considered? Say about ratio.
because, my lord, this delay is done by the department, my lord. With all respect, my lord, in this regard, my lord, I have also annexed some judgment, my lord. But some other judgment I will come. I have annexed, my lord, but I
You be ready on next Thursday. This Thursday. On the prayer of
is delayed by the department, my lord, not
and
not the stand was as a judgment.
be listed them. We'll see that.
Diploma.
You seek a suit for their people for compensation.
They are, my lord, helpless before the mighty, my lord, state, my lord. But
No.
they are, my lord, if neglecting, my lord,
We'll pass the
now, my lord,
law is well set. We'll pass the order first. Of course, after hearing you and looking into your judgment. Yes. Why? This is item number. Yes, records available.
So I have received a record, but it's not the relating to this. After
That is not our business. Lookout.
I will
We have said you bring the record. We are asking whether the record is available. You will have to say no. So say no. Don't say that records are there, but it's
they
something
have
different.
sent
That is
the
not our lookout.
Sir.
The learned counsel for the GMC submits that he will need require some more time to produce the record in terms of this court's order dated 22/11/2020. Accordingly, matters that adjourned and be listed on
it is
any date will not. We will
Next
have to.
week,
Will
next week.
otherwise we'll ask for personal appearance
next week, madam.
next week. You had it 13th.
Right.
I prayed for time in the morning, my lord. So we are directed to file an supplementary affidavit annexing the proposed reply and the recovery. Altogether, there are 72 petitioners, my lord. 61 we could collect, but 11 we are still not available. So that is better.
Okay. Mr. S.K. Chakraborty, learned counsel for the
Respondent.
respondent FCI.
Yes.
Respondent FCI. Prays that he may be granted a week's time to produce the file the affidavit.
Paragraph 11 of
File
the
the affidavit in terms of this court order dated 19/9/2023. The prayer is allowed. Please this matter.
Can it be earlier, my lord?
Well,
Sure.
First, if instructions not yet received in this circuit, we written to them on 30th of August. What should say, give me 2 weeks time, Your Lordship, as the
learned State Council submitted that he has not yet received instruction. Accordingly, he prays for and is granted 2 weeks time to have instruction and file the affidavit. List accordingly.
Time is after.
Time being,
Getting the tablet.
termination, affidavit file, appeal preferred, yes. Time being. This is item number 28. Somebody sought an adjournment in the morning. It took okay. Okay.
Lordship, we have received the instruction.
Waiting for instruction, receive. What is the issue here?
Issue is whether there was any post vacant.
Commission requirement.
Matter. There was a post vacant there as per this particular instruction code. Next page, Your Lordship.
File an affidavit.
Date.
Huh?
Date.
The Lawrence State Council submitted that they have received the instruction and will require a week's time to file the affidavit. Week's time? 10 days.
10 days.
10 days time to file affidavit. Accordingly, matters and adjourned and be listed on
16th, Your Lordship.
16/12/2023. In 16/12/2023. In the meantime, the respondent shall file their return back.
Long time pending, my lord, for more than 1 year.
Yes, what you say?
So if the here it is a accepted matter. So if it is in accepted matter, so there is no scope of appointing an arbitrator. Lord,
I'm not getting it. What is that accepted?
Lordship may kindly take up page 50.
Page?
50 of the writ petition.
Yes.
So as per the clause 63, Lordship is getting. I have also given a standard that is also there, Lord.
Okay, 50.
Page 50, clause 63. Matters finally determined by the railway. All dispute and differences of any kind whatsoever, so and so connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract referred by the contractor to the GM, and the GM shall within 120 days of receipt of the contractor's representation, make and notify decision on all matter referred to by the contractor in writing, provided that matters for which provision has been made in clauses 8, 18, 22, 5, 39, 43, 1, 45A, 55, 55A plus 5, 57, 57A, 61, 1, 61, 2, and 62, 1 of standard general condition of contract, or in any clause of the special condition of contract, shall be deemed as accepted matters not arbitrable, and decision of the railway authority thereon shall be final and binding on the contractor, provided further that accepted matters shall stand specifically excluded from the purview of the arbitration clause. So here, Lordship, it says 60, it's covered by 62 1.
62.
1.
Where do we
62,
get
yes,
61?
Lordship, here, Lordship, the yellow flag I have marked as general standard of contract. 62 1 clause 6, Lordship.
62 1.
6. Abandon the contract.
Okay, so 62 clause. Where is that 62 2?
62 1. Then next is clause 6.
I've got 62 1, 62 2, 62 1.
62 1. 62 1 has these other clauses.
Okay, so, okay, Roman 6.
Roman 6. Roman 6, abandon the contract. So here, Lordship may kindly see this is first, Lordship have to go through thereafter, Lordship. The contractor has not completed the contract, nor he has there is any specific.
Where is your decision that it is treated to be an abandoned contract?
Lordship, yes, Lordship. Lordship may kindly come to here we have given him 7 days notice, Lordship.
Where is that?
7 days notice. Lordship may kindly come to my affidavit, page 132. Page 132, notice dated 1/3/21.
130.
2.
It's a termination.
Lordship, this is the 7 days notice. In reply to this, Lordship, the read petition page number 68 and 69, Lordship. 1/3/21, we have given him 7 days notice.
68 and
68 and 69, relevant portion, page 69.
Yes.
Lordship may kindly see second para, third para. Now, in order to avoid further financial loss for the balance work due to abnormal hike in the cost of construction material and labor cost by around 30%, which is estimated to be around rupees 3 crore, in addition to the unanticipated financial loss already incurred due to the aforesaid hindrance, which is beyond our control, it is not feasible on our part to resume the work any further. Rather, better to foreclose the work.
So according to you, if by virtue of this, they have abandoned the contract on their own holiday.
Yes.
So therefore, it is non-arbitrary clause covered.
Then 10/3/2021 is 48 hours notice, next page, Lordship. Then we have also given him 48 hours notice before termination. So there is no.
So, was there any necessity to terminate beyond this? You ought to have said that this is that they have abandoned the contract. Now, if there is a subsequent termination, whether it is a termination or it is an abandonment, that will have to decide day after tomorrow.
Well, the time-
I'll just go through it. That's why I'm saying paper. No, you just, if anything you can show. What will be your case? Your case will be that when there is a termination order,
Yes.
it is a termination.
Section 63 has been given, difference of 30 days. They have not replied to that. They should have decided that. They have not decided. 120 days time has been granted to them. 180. They have
Okay.
not decided.
I'll just go through it
Clause
because
64 is there, which differ from 120 days also lot. If it is an accepted.
okay, which are the important clauses according to both of you?
62, 63, 64.
Just a minute of the writ petition or in the arbitration petition, the agreement contract between
Yes,
for the work.
that
Which are the clauses?
62,
62,
63,
63,
64.
64.
These are made.
These are the contents of it. And from the general clause,
From that general concept.
from general 60 to 60 to 64.
60.
And what about the others? That agreement, that is only the arbitral
Yes.
clause. Arbitral clause is which is the clause? Arbitral clause? No, of the agreement between you and them.
Yes.
Clause 63.
64.
64. Case
64 is
64 is demand part.
50, but clause 64 page 50 of the RPT.
I'll just go through it.
Yes, sir.
You also be prepared. Your case is that moment you say, simple case, moment you say that will not execute, irrespective of termination, it should be treated as an abandoning the contract. And when it is an abandoning the contract, the arbitral clause is there is an exception, so arbitral clause will not be applicable. Mr. Sahala's case will be that after that you have even issued notice and issued a termination. So it is a case of termination, not a case of abandonment. So therefore, when it is termination, exception will not be applicable. And this point you have not even raised when we have filed our claim. You have raised for the first time here on.
Yes.
This is the simple. Okay, we'll see day after tomorrow. After criminal cases for slowly brain is to settle. Yes, Mr. Deka, what is this?
As for the order to report and
Promotion or what?
regular. Your top talking the great
To file an affidavit. This affidavit in opposition in respect of which repetition? 11113 of 2022.
Yes.
So affidavit has already been filed or what?
Subsequently,
Now what kind of instruction did you correction of name?
it's
Yes.
clear.
Sajid Ali or
Ajit Ali. But what is your that stand is not clear here.
Not.
Then affidavit, I thought that you have not filed affidavit, but you have filed affidavit. What is the stand in the affidavit?
but should have not Concerned department, like I'm Kazi, even my name is on this official record, the annexer 3, kindly have a look.
No, what is the dispute then now?
No dispute, my lord. So therefore, one place my name is written Aziz Ali. All this correct. Only Aziz Ali.
Now your case is not regularized. Okay.
Other similarly placed participant much more junior than me were regularized and left out.
Okay, we'll take a final call on this.
Yes.
If they have not done, not done. No instruction here. With Tajid or Ajit. Now, only issue is that his case is that because of misspelling of my name, I have been deprived. What is your stand?
And that was actually that direction was thought for in the last week. This inspection has coming.
You have the instruction. The learned standing counsel for the PNRD department, Mr. N.K. Devnath, learned standing counsel for PNRD department, submits that though instruction has been received regarding regularization, however, you are getting 15,000.
Yes, sir.
15,900. 15,900.
All others are getting regularized.
The other person, they approach this on our report, they are
Okay. You are getting only 15,000 with DA. But that is the division bench decision. The other persons were regularized prior to division bench decision.
not subsequently after
But
2021 they have
regularized in terms of division bench judgment or what?
not they highlighted this petition may not then contempt could have clarified then accordingly they will even they pass they have considered the regulation in view of the contempt with order. I have enforced all order there.
Okay, we'll decide then. But it is not clear from such instruction whether the petitioner's correct name is Tajid Ali Bepari or Azid Ali Bepari, and whether only for the misspelling of the name the petitioner was deprived from his regularity. Accordingly, Mr. Devnath submits that affidavit has already been filed. He will take a specific instruction on this point. That is whether the name of the petitioner who claims to be Tajid Ali Bepari, who claims to be Tajid Bepari has been misplaced as misspelled as Azid Ali Bepari, and whether only for such reason he has been deprived from the regularity. You have the specific instruction.
One annexer considered page 29. The annexer page 29 because my name is correctly written because issued by the Joint Secretary Commissioner. Page 30, serial number 21.
We'll come to that next date. Then if he comes with the instruction or not, we'll decide on the basis of the material available whether you are Tajid or Azid.
Yes, sir.
Is there any Azid in the department?
Mala, actually, there was a certificate issued from him, his hand actually, where actually this name was, the confusion actually was created from the petitioner.
By him. Okay, we'll see. When can you have it? Simple, you have a telephonic instruction. Just forget about, don't give all this. Affidavits are there.
Towards the end of
Next week. End of the next week.
Friday.
15th of.
5th of.
You have that. Otherwise we'll decide it. If he's entitled, he's entitled. If not, he's not. Yes, what happened to Iqbal Hussain?
May I please? Because while I was serving as a senior engineer, this picture development block under the Panchayat development is subjected to a departmental inquiry by issuing a charge memo dated 5/2014. Now, that departmental proceeding not be culminated due to want of witnesses, which they have added, along with the list of documents and list of witnesses. As a result,
my promotion from my lord the next category to the next
Now,
category.
what happened to the departmental proceeding?
Still, my lord may kindly verify.
Your
from-
case is not considered even under seal cover.
My lord, they have said it is under still cover.
Ah.
It has not been finalized due to want of my SPR. My lord. That is their stand.
Ah.
If my lord, just for a moment, verify the affidavit, my lord. Running page 133, my lord. My lord, running page 133, paragraph 19, may I read, my lord?
Yes.
That with regard to the statement made in paragraph 26 of the writ petition, your humble deponent fact to stated as per the minutes of the departmental section board meeting held on 2021. The proposal for
When the departmental proceeding started?
Lord, it was charge memo was on 5/2/2014. My lord, my charge memo maybe please to verify, my lord, is that page,
Page page?
my lord, page of my writ petition. Starts at page 82, annexure 11.
Then what happened after
My lord,
charge
I have
memo?
submitted my
Inquiry report, inquiry committee.
No, my lord, the inquiry committee has been constituted. That the process has not been, my lord, proceeded further even after filing of my written statement in defense.
So according to you, no inquiry officer
No,
has also been
No,
appointed.
inquiry officer has been appointed, my lord,
Appointed, but there is no hearing
no
or
hearing because they do not have the witness. They are summoning repeatedly the witnesses, my lord, but the witnesses have not responded to statement.
when inquiry officer was
My lord,
appointed?
please to find from their affidavit itself, my lord, they have
No,
initiated.
says the date.
Yes, sir, it is on 2014, 21st of April, my lord.
21st of
21st of April, 5th of September 2014 at page 138. 5th of September 2014.
9/14 inquiry officer appointed.
Appointed.
And thereafter nothing.
No, my lord. And there, my lord, the latest status report which they have furnished,
Mm.
my lord, is also is at page, running page 139. They have said, my lord, why the inquiry could not be culminated, a detailed finding has been given.
139.
Page 139 of the affidavit. Status of the inquiry of the DP drawn against so and so junior engineers for development.
How many witnesses were cited?
Lord, from their statement of allegation, list of 7 witnesses.
How many examined?
No, my lord, there is no examination as per my information. My lord, may kindly
So
verify.
that Soilesh Singh
My lord.
appeared on the one day.
One
It
day,
was
one
at
day,
6:30 because
My
of due to delay in flight.
delay. But there are no advance.
Yes.
I have heard that some of the witness.
Succumb to pressure or what?
My lord, due to various reasons. That is one thing.
That will be not their succumb. That will be that they have expired. Succumb will mean under your pressure. Yes.
This was someone, but none of them actually appeared to being informed.
Who? That is your witness.
It's true, man.
Can a matter be proceeded like this?
True, man.
Then open the seal cover.
So, my lord, may give a direction that within a time limit.
You are having it from 2014. We are almost 2020,
That is true.
2024.
But then the
Where is the scope of giving? When this year started?
Lord?
When this
The first hearing was in
witnesses
2021.
started?
2021, my lord, the first hearing. 8th of November 2021. First hearing.
First check. And before that, what was the date of filing such it?
5/2/2014. My superior.
Who was the so-called person?
My lord, this is that page 82, my lord. long term, type it out. So,
where are the charges?
Lord, you are therefore charged with the breach of trust, page 83, my lord, misappropriation of the government funds, violation of the government guidelines, and misuse of official capacity for corrupt practice. Now, my lord, in detail, I have given my reply, my lord, in my written statement in defense. My role and how I was, my lord. Actually, my lord, what has happened before this inquiry, my lord, another inquiry was initiated, wherein, my lord, I have been charged that the
Now,
amount,
where is the list of witnesses?
my lord, yes, my lord, it may be found from the page, my lord, page 92, my lord. List of witnesses, my lord, 7 numbers.
Clearly
92,
written at page 87.
page 92.
My lord, page 92 is the document. Initially, they have relied on document, and this is the list of the document from serial number 1 to 29. And then these are the list of witnesses from serial number 1 to 7.
Serial number 4, that witness at team lane.
You want to see the record of the we'll see why it did not happen. If we see that it's a casual approach, we'll say that no further record. The petitioner, a departmental proceeding was initiated against the petitioner by issuing a so-called notice dated 5/2/2014. The petitioner replied to such so-called notice by so-called notice along with statement of allegations, list of witnesses and the documents to be relied upon by the department. From the aforesaid, it is seen that the department is relying upon 29 documents to prove the charges. The department is also relying upon 7 witnesses in this regard. Pursuant to such so-called notice, the petitioner replied by its written statement dated
20/0/2014.
20/06/2014. According to the petitioner, though enquiry officer has been appointed on
21.
the enquiry officer was appointed on 21/16/2021. 1/6/2021. However, according to the petitioner, till date, not a single witness has been examined, and in the meantime, the petitioner, two promotion consideration for promotion on consideration promotion twice has been denied to the petitioner only for the reason of the pendency of the departmental proceeding. Therefore, the present petition is filed assailing the continuance of the departmental proceeding as well as for grant of promotion to the petitioner. The respondent have filed a written state, filed an affidavit in opposition in the present proceeding and has specifically taken a stand that case of the petitioner was considered for promotion by the Departmental Promotional Committee and same are kept under seal cover and could not be opened for the pendency of the departmental proceeding. It is seen that so-called reply was so-called reply was filed on
2014, it's on 2006,
2016
14.
14 and department took almost 15, 16, 17, 18, 19, 20, 21, 7 years to appoint an inquiry officer to proceed with the departmental. Not only that, not till now, no witnesses has been examined, though on one occasion the witness listed against serial number 4, 407, 44, serial number 4 was present beyond the time of inquiry, which fixed at 10:30, and inasmuch as the aforesaid witness appeared before the inquiry committee at 6:30 p.m. with a explanation that due to delay in flight he could not appear in time. Be that as it may, as the basic ground for challenging the continuation of the proceeding is the delay, this court thinks it appropriate to look into the record of the proceeding to ascertain the cause of delay. Accordingly, the learned standing counsel, Mr. N.K. Devnath, shall produce the record of the inquiry officer pertaining to the departmental proceeding in question. Please this matter on
What's the end of next?
Huh?
What's the
end of next week. Okay, give it.
Right.
15.
Apply.
Have some judgments. Have some judgment that it is.
Apply.
What is this item number? Yes.
There were seven to advertise.
Hmm.
Eight
Hmm.
right. The advertise for corporate 74
Hmm.
out of 20 among the the what?
Promotion.
Yes. For the 25% the matter for corporate. They stick to I am the it is qualified lot. And I plead for direct. I think
No. How many posts are vacant?
20.
20 posts vacant.
Yes.
In under ICDS?
Corporate.
ICDS, Hormosala. Okay, now according to you, post advertise 17.
70.
20 vacant, post 17. Advertise. Now, advertise, what is the percentage quota for direct recruit and promotion? So then what is the number of 25% and 17%?
25% of 70 secure.
Okay. 25% for direct recruit.
Yes.
2 posts are vacant.
I for promote.
25 promotional. So it will be 3.
Yes.
And they have call for all
Yes.
advertise. And what is their stand in affidavit?
Otherwise, that I have thought that it is also that I have.
No, you are
I have a certificate of rating. I have direct.
so you say that even if I am working,
Yes.
I want to participate in direct recruit.
Petitioner is a intending candidate. If the advertisement is issued for direct recruitment, then the petitioner will get a chance to participate.
No, what is the total number of posts earmarked for direct recruitment?
Yes.
And first question. Second question is whether this this quota is project wise, ICDS wise, or district wise, or state wise.
I think it's for the child development.
No, we understand. suppose we take your argument and accept it.
Yes.
That there are 100 posts in this ICDS, 25 posts to be promotion, and rest 75% is for direct recruitment. You are an intending candidate. According to you, I am an intending candidate. I want to participate in a Are you working as a helper?
No.
No. So you are intending. So according to you, the post meant for me is being filled up to the promotion which is not permissible under law. This is your case?
Yes.
Now, if this is your case, you will have to first satisfy that these 100 posts under the ICDS, the quota is to be calculated on the basis of the project, not as on the basis of the state. Because there is in one district there are many projects. Now it is a project where 20 in
Yes.
one project so many posts are vacant.
Yes.
Maybe. So now you will have to show us that this recruitment or quota is project wise. Where is that? Page 9. No, vacancy is different.
Yes.
And filling up of quota is different. How they
Yes.
maintain this proposition? Suppose in Huh? page 13. Yes, not what you say.
Lordship may kindly come to annex.
Whether the other persons who are intending for promotion are parties there.
In fact,
both the
Hmm.
Right?
Advertisement stays against the interest of the state.
Yes.
Isn't it?
Malad,
We want the Anganwadi work centers to be run.
Yes.
If somebody is appointed
Yes.
without promotion, they will revert them back. There is not a problem.
Beyond that, they make them appointed what?
Hmm.
But that the order of it.
Now, kindly show us that before that you show us the advertisement.
This part is that. Nothing. This part. With the
Okay. Okay, then what order you want to show us?
yes. Sanctity
This order.
sanctity they are
before that, the first order is 2311.
Hmm.
Order is
22.
the order. In spite of all the order, he hit the effort. And the court observed that they are in the court of
Where is that order? 22.5.
yes.
Yes.
Yes, but
What is the
there
instruction thereafter? It's not go to that. Are you having a copy of that order?
Yes.
Here.
The first order, Lordship will be 2311.
23/11,
23,
23, 23rd of November,
23rd of November 2020.
22,
Orders are placed in 22,
20, 23,
23/11/2022.
yes, well, there Lordship has said that in respect of that Anganwadi center not to act upon on the advert. So my instruction is that the order was passed on 23/11.
Hmm.
The upgradation has been done on 17/11. But after receipt of this order, that 17/11 order he has paid in respect of that Anganwadi. So here Lordship will kindly see.
Okay, for a time being, let us not go to that.
Look.
Let us for a time being not go to
Yeah.
that. Because if you will have to file an affidavit verify that it was done prior to and it was
That-
in your not notice, then already there is a finding that it's a clear case of contempt. So we'll have to come to a finding that this is not a contempt because this was okay, that will come later.
Look.
But what about the fundamental argument?
Fundamental argument is Lord, they have challenged the advertisement on the basis of Annexure 5. Annexure 5, we have filed a detailed affidavit of the Director Women and Child Development has filed the affidavit. So they said that the 6th of October 2006 is a letter given by the Government of India that 25% post has to be considered for promotion. In fact, Anganwadi worker and helper, there is no concept of promotion, it is upgrading. What happens, Malak? In one Anganwadi center, there is one Anganwadi worker and one
helper.
Anganwadi helper. Because of
And one supervisor.
supervisor is a government post.
Okay.
The Anganwadi helper and worker, they are under the scheme, they are not honorary basis, they are not holding any public post. It is the decision is there. But I have filed the affidavit, there we have taken. So because of some circumstances, if the Anganwadi worker left or some Anganwadi worker died, for that, the government of Assam has prepared a notification 4th of March 2023 at page 22. Lordship will find that in the writ petition they have an act. This is a scheme formulated by the government so that it can give a opportunity to the Anganwadi helper to be upgraded as an Anganwadi worker. So normally the scheme is the Anganwadi worker and the helper has to be within the survey area of that particular center. Here, some scope has been widened, and it said that the Anganwadi helper in a revenue village, there may be 4 or 5 Anganwadi centers, but in a survey area there is only one Anganwadi. Here the scope has been extended, and the Anganwadi helper of that Anganwadi within the revenue village, clause 9. I'll take your lordship to that. So all the 3 or 4 Anganwadi helpers, they get an opportunity to be upgraded where the Anganwadi worker post is. So that is this notification, and following this notification, the advertisement has been issued. Under that particular ICDS, my instruction is 230 Anganwadi centers are there. But this advertisement has been issued to fill up 20 posts of Anganwadi worker because of some exigencies, those were fell vacant, and this is giving an opportunity to the Anganwadi helper to be upgraded as Anganwadi. This scheme, it provides, clause 9, the promotion, although the word is promotion, it is promotion upgradation.
Whatever that, but what is the principle 25%, 75%? Where do you get?
We have said that this 6th of October 2006 is a letter from the Government of India. It's not a guideline, it's not a rule. And for the Anganwadi worker and helper,
Union of India is a party. Who sponsors this finance of Anganwadi center? Who pays the money?
In fact, the orders of the Honorable Court as well as the Honorable Apex Court, we have mentioned in the affidavit, but I'll take a look.
Okay.
The affidavit has been filed with the director. We will take a look.
We'll take it up Thursday. Finally.
Look. I'm indicating one thing. The affidavit filed by the director is there.
Okay, I'll go through it.
Yes. In the affidavit,
Somehow I could not go through it.
in detail, we have filed.
You have filed reply to that affidavit?
Yes.
Huh?
Already I
No. To his affidavit?
Yes.
It should not be that half the way we start and say that you needed to fight.
No. I
Thursday.
Look.
We'll decide on it. Important issue.
Yes.
You be here on that.
Yes.
May I? My lord, in this case, what happened? The lead petitioner.
Just give me a minute. Okay, show us your appointment.
Upon page 34.
Is
34. Connected to. It is selection. Selection of petitioner. In the earlier round of selection, my lord, was selected serial number 1, finance manager Jahid Mohammed Akbar, selected. Then next page, my lord, he was asked appear for the my lord CEO for reporting and joining.
where is your contract?
Contract, my lord, initially contract was signed in the month of March 2023 and effect was given from 1st of July 2022. Effect was given in paragraph 1, page 37.
Where is the termination clause?
Termination clause, page clause 17. Page 38. For misconduct.
No, and other termination of the contract. Any other termination clause? This is termination on certain exigencies.
If at the
This validity period of this contract
was up to my lord, again it was renewed. Initial agreement was up to 5th of up to March, my lord, July 2023. Then it was again renewed. It was proposal was made for the my lord CEO on in the month of May. He has not approved because of the fact that my lord, I have specifically Melafeti, I have my lord, I have stated, and in that paragraph I have stated that he made a proposal.
where is the last contract?
Last contract, page 40, annexure 5.
It was with effect from
With effect from
7th of July.
Yes.
And till
my lord, 2024, 30th April
where do you get that?
page 41, clause 1. Page 41, clause 1.
Okay. Okay. Now, where is your termination?
My lord, page 44, next C.
Yes.
My lord, then my lord, next page is my representation. I have filed the representation immediately thereafter. Page 45. I have explained the position. From paragraph 1, I have explained the position which are reflected in the, my lord, termination order. And so far as the termination part is concerned, my lord, the Assam Steel University project, they have a, my lord, they have a separate policy, my lord, which they apply. My lord. in this policy, there is a detailed procedure to be
Till
followed
procedure of what?
for termination. Before termination, there is a procedure.
To which employee? Contractual or regular?
Contractual. All are contractual employees
You
there
are appointed by whom?
by the chief executive officer, pursuant to recruitment by the Assam MD mission director, Assam Steel Development Mission. Disciplinary procedure, page 24. Down below, the page mark. Down below, page 24, disciplinary procedure. This is Assam Steel University Project Human Resource Policy Manual. This is the manual by which they have guide. That should follow this. No warning, no counseling, no notice was given to the person. This provides for a procedure before termination.
What is the statutory value of this?
But they have to follow, my lord. And
Why?
secondly, my agreement is in force. What happened, my lord? The chief executive officer requested the, my lord, present petitioner to keep a paragraph
See, they
15.
have given
Lordship, kindly
reason.
see
They
paragraph
have given reason.
Yes, paragraph 15, Lordship, kindly. Paragraph 15. 1 5.
First comes to
Page 24.
page 44.
Good.
So, as per your term, in certain circumstances, you can be terminated. And apparently, prima facie, they are not satisfied with your performance.
But misconduct has to be proved.
Where is that misconduct? There is no misconduct.
According to them, my lord, according to the policy, there should be misconduct. Agreement.
You have a contract with your employer.
Yes.
Terms of appointment.
Yes.
In terms of appointment, if your performance will be assessed, if it is below something or they are not happy with you, then they can issue a termination order.
That's not there.
Huh?
That's not there.
Kindly come to
Lordship, kindly come to paragraph.
No, we'll go to the other part later on. This is a binding contract between you and them.
Right.
Kindly read clause 3 at page 41.
The term of the engagement shall be purely contextual and shall automatically terminate after 30th April 2024 in PMU and ASU project. If not terminated earlier based on unsatisfactory performance, conduct as solely determined by the chief executive officer or extended based on satisfactory performance, conduct as determined by chief executive officer or link further extension of the project period by Government of Assam, Government of India, and also Asian Development Bank. There is nothing in the record to show that my performance is unsatisfactory.
So, why not? These are the language.
My lord, language and lordship, kindly see paragraph 15.
Kindly come to page 44 first. We'll go to the policy decision later on. Page 44. Your termination is a result of careful consideration of your job performance over an extended period of time.
Correct.
Despite our efforts to support your professional development and provide additional resources, your performance has not met the standard expected from your position.
I have specifically stated there is nothing as such of record.
We'll examine
and
it.
paragraph 1, lordship.
We'll examine it.
Lordship, paragraph 1 or termination. In the aid memory shared by the page 44, paragraph 1. In the aid memory shared by the Asian Development Bank on 26th of April 2023, observation regarding the function of finance management team was raised. This was also flagged by the undersigned many times. However, no major remedial action has been observed at your end.
So we'll examine only, not beyond that.
What happened? This is in the month of April. Thereafter, my agreement was renewed. This is in the month
That's why they say even after extension, that is not satisfied.
My lord, what happened, my lord? Nothing is such, my lord. Only, Lord, kindly once for a moment, paragraph 15. Lord,
We'll-
kindly see.
We'll look into this. We'll
Paragraph 15,
examine it.
Lord, kindly.
We'll examine it. We are issuing a notice. Not
my
beyond that.
My lord, status quo is unputable.
No status quo. You
What
are
if- what-
already term.
What happened, my
We
lord?
cannot injunct a
My lord,
concluded contract.
Lordship, advertisement page 55 was issued after his transfer, my lord. Why, my lord? He intended to fill up the vacancy, my lord. His transfer order at page 53, Chief Executive Officer. And my only fault is that, my lord, I have not accommodated his allowances, which is not permissible as per the police demand. I have stated in paragraph 15. He was transferred by letter dated 29th of November,
Who has transferred?
the Chief Executive Officer, who has accepted the advertisement, page 53, my lord.
You participated in the selection.
My lord, page 53, my lord. This he was transferred, second paragraph. Next, he was IPS officer. Next paragraph, next day, he made an advertisement that walk-in interview is to be held on 5th. Nullified everything, my lord. Lordship, what happened? I have stated, and if
It was published when?
published on second,
He might have given to the newspaper, you publish it. There he may be transferred in between.
my lord, he was already transferred on 29. Immediately next day, day after 2,
He might have requested the paper or whosoever that will fill up this. When
Well,
your termination order was passed?
16th of October.
16th of
Then I filed a representation, and they personally called me to the office. I have stated, and they
See, we address the case of notice.
if my lord, if the post is filled up, then my lord, third party right will come in.
If the post is not filled up, then somebody will suffer. We
My lord,
cannot
what
put you back.
My lord, I have handed over
The institution will suffer.
my lord, I have handed over the lord people.
We'll
Consider
have
the
to
record.
balance.
I have handed over the my lord charge to the accountant in terms of the termination order. He is holding the charge. So my lord to take the matter after 1 week. In the meantime, they produce the record. Lord will consider and pass the final word. And status quo with regards to situation matter appointment matter. Because if appointment is met, matter third party right will come.
It is a contract.
Yes.
We know our limitation. Can we injunct putting a terminated contract to a life?
I am not saying, my lord, that
whether termination is
lord,
bad or good, we'll examine.
my lord,
If necessary, you maybe if we can decide it before, we cannot suppose we give a status quo, matter is not taken up. We cannot go beyond 34, even if suppose they do not extend the contract on 34. You know your nature of employment.
Yes.
Isn't it?
But my
So you have many remedies to avail. If that is wrong, bad, you take a compensation.
my lord, the punitive, my lord, action on their part they have stated. But that is
It's not a punitive action.
my lord,
because your contract itself says on the basis of
my lord, my
unsatisfactory facts.
misconduct has to be proved, my lord, before termination.
Not necessary. Then there will be no value of this contract.
My lord, if my lord, contract, my lord, they have their own policy. Policy states that, my lord, there must be warning, there must be counseling and all that.
We want to say as today itself that this policy is not having any statutory force and that will not give you a statutory right under this. This is a policy guideline and violation of the same will not give any.
My limited prayer is, my lord, they may go on selection, but so far appointment is concerned, that may be after next week. Limited prayer.
Third, Mr. Spencer J.M. Choudhury, Learned Counsel for the Petitioner. Also heard Mr. Bhatt, Learned Counsel for the respondent numbers.
My lord, 1, 2, 3, I will appear. 4 is by name.
By name.
1, 2, 3. Issue notice the respondent 1, 2, and 3. No notice need be issued the respondent number 4 at this case. The petitioner was appointed. Petitioner is a contractual employee working as finance manager under the respondent number
My lord, 2 and 3.
2 and 3. The last contract was entered into between the petitioner and the employer on 1/6/2022.
Lord.
Huh?
7th of July 2023.
7/7/2022.
23.
2023, and the validity of the said contract shall expire on 30/4/2024. Full stop. The clause 3 of the contract provides that, where is the clause 3?
Page 41.
Provides that the term of the engagement of the petitioner is purely contractual and shall automatically terminate on 30th of April 2014. 2024. Full stop. The said clause further empowers the employer to terminate the contract earlier to 30/4/2024 based on unsatisfactory performance / conduct as solely determined by the chief executive officer or extended on full stop. The petitioner was issued a termination notice when? Where?
My lord, on
44.
page 44.
Termination notice on 16/10/2023. Purportedly after consideration of job purportedly on the ground that after consideration of job permission of the petitioner over an extended period of time, the petitioner could not improve his professional development despite the effort of the employer. Full stop. And certain specific incidents were raised. The petitioner filed a reply on 19/10/2023. However, such representation, however, by the impugn order dated, no, there is no termination order thereafter.
No.
Representation. In the meantime, an advertisement was issued on 3rd of November 2023 to filling the post which the petitioner held. Full stop.
Should be second.
Second. Issue notice returnable after 4 weeks. Mr. Dhar accepts notice on behalf of formality. However, extra copies be furnished to them. On the next returnable date, let Mr. Dhar produce the record pertaining to the termination of the selection. The respondents are permitted to continue with the selection process and the appointment to such selection shall be subject to outcome of the presentation.
Okay.
Yes. Hmm.
On 5/1/2020,
Where is that?
page 21.
Okay. Then
There, right, there are pictures with different standards with the name of the declared page 20. Last part.
what is this document? Accepted candidate.
Yes,
Okay, page
the date of interview plot page 20. Last year number 50.
Jacqueline Nahar.
Is
19/5
and
interview.
against that
Okay, then
that was not there. Then second is put and published on that page
29.
29.
Okay, then
That shows the name of private respondent how hard candidates have accepted the last step was right or it had
No, suppose her application was there by mistake, it was not considered.
accepted the candidate shared
Prepared. Suppose there is a mistake on that. Suppose her application is just everything was there. Will the employer will be debarred from that publishing a corrigendum that no this her name was
nobody was
no issue. So they have recasted the entire list. If it happens, are you having an indisputable right to be the sole candidate? Your case is that her candidature was subsequent to the last date. We'll examine it. Will not stay anything.
They were the landlordship hard accepted date was prepared and saying that interview with if
Is your name there?
along with the private
Okay, we'll say that your allegation is that private respondent filed her application beyond the last date. Otherwise, you don't have a case. That should be your case.
That's not the market. If
Uh,
her candidature was accepted
so that
illegally,
illegal.
there is
Then
no point of
definitely,
appeal the
and
petitioner
that
for the
according to this code, this is a premature stage of this petition.
later may arise that it that is the
Okay, so therefore we are issuing a notice at this stage, allowing them to proceed with the selection. However, such selection to the specific Anganwadi center shall be subject to the outcome of the
father not working there since the date the helper left resigned from the
those are
these are all lordship
these that will consider later on, but whether only because of giving a land any contract,
not
It-
after placing those
that will examine.
Sure.
R. Chaudhary, Learned Counsel for the pursuant an advertisement dated 19/12/2023 for filling up of the post of Anganwadi work worker / helpers of different Anganwadi centers under Mayong ICDS project. The petitioner applied for the post of Anganwadi helper of Belbori Muslim Gaon. Belbori Muslim Gaon Anganwadi Center. By annexer, no, last date of filing of the application was 5/1/2023. By annexer 2, the respondent authorities issued an list of accepted candidates for different Anganwadi centers for interview, and so far relating to the petitioner and so far relating to the application of the petitioner was shown to be the sole candidate for Belbori Muslim Gaon Center Anganwadi Belbori Muslim Gaon Anganwadi Center, and her interview was fixed on 19/5/2023. Subsequently, by Annexer 3, yet another accepted list was published by the respondent authority, wherein the name of the private respondent is shown along with the present petitioner, isn't it? And the date of interview was shown to be fixed on 30/11 to 2023, and thereafter yet another accepted list was published on published showing the date of interview on 7/12/2023. It is the case of the petitioner that on the last date of filing application, that is on 5/1/2023, the private respondent did not apply for such post and only to accommodate her, the subsequent list, only to accommodate her and some other candidates, the subsequent list was published. Full stop. Issue notice, 4 weeks. Mr. Thor, 1 to 4, all respondent.
Private.
Okay, notice to the private respondent by registered post with AD as well as visual process. So visual process. You are working as, where do you get that?
And the hardware equipment of
Okay.
my
Okay.
standard
Okay.
house.
Considering the method in entirety, it is provided that the selection to the post of helper in Muslim Gaon Anganwadi Center are under Morigaon ICDS, isn't it? Under Morigaon ICDS shall be subject to the outcome of the writ petition. Mayang ICDS. Belbori Muslim. Shall be outcome of the final determination of the present as to whether the candidature of the petitioner, whether the respondent number 5 filed her application beyond the last date, and if yes, whether her candidature can even be considered for that. We'll see. No, let us see. The petitioner is permitted to file an IA in the event the respondent is selected or respondent file is selected to the post. We'll see. In the meantime, you just use that is only. Simple.
Whether
Suppose her application was there, then it will be a different issue. We cannot say that application, suppose there may be mistake, or it may be a malified exercise also, that you are taking application, and what is the why you are used to publishing differently. You can very well change the date of interview, that we could not have held this list.
number of candidates of the
that is the appointment. In the interim, it is provided that the respondents may proceed with the selection process to the for filling up the post of helper in so-and-so Muslim Gaon ICDS project. However, the result of the same shall not be declared without leave of. One side you will argue that these are no posts, these are voluntary work, and thousands of people will participate, and you will say these are not posts. Yes. Yes.
My lord, in this case, I am appealing on behalf of the respondent number 2 and 3. And
This is item number
34. So respondent number
admission.
respondent number 3, the PTPT is, my lord, already we prepared and sent it over for vetting.
Okay.
Election. So within 7-8 days we
Okay. The teacher Mohanto Lord Senior Counsel arguing on behalf of respondent number
2
and 3. Praise that he may be granted some time to file
that you are sent for
the file an affidavit. Huh? What? Prayer is allowed. This matter. New Year. 18. Who knows 18? All Muslims will be there. Okay, 18.
already daily action.
Well, matter related to compensatory effort. Lordship, petitioner case was recommended by the DL against a specific vacancy against the road company, but the SLC Lordship rejected my case.
What?
On the ground that Lordship already persons were appointed Lordship in the compensatory appointment process. That Lordship could not be recommended as three posts are already occupied by persons appointed on compensation ground, which constitute more than 5% of the cadre.
Then
But Lordship, the list which was furnished by the Additional Deputy Commissioner Karimganj Lordship at page 40 Lordship, the vacancy position as well as the cadre strength of the grade 4 post Lordship, page 40 Lordship. They are mentioned Lordship that total vacancy position in the grade 4 post process server as well as peon Lordship. There are two types of grade 4. 16 posts in process server and peon there are 38 posts are vacant. And total cadre strength was Lordship 39 and 58, meaning thereby there are 97 posts. So approximately 5 posts should be recommended for the compassionate effort. So as per Lordship, minutes of the SLC Lordship.
no, there is another aspect. Suppose a person was under the waiting list under clause 15. That person is appointed. Then
Lordship,
already suppose 5 are appointed from different department. Then
yes, Lordship. I am also agree, Lordship. But
if
fact,
that is not that possible. That is possible.
maybe.
If that possible, then they will have to clarify any affidavit file.
No, Lord.
We will have to clarify this disparity. Somebody says that this is the vacancy is available. SLC says vacancy is not available. On what basis? Under what calculation? So what?
Okay.
If no vacancy, you have given chance to somebody else, no way out. And if even after vacancy you have casually made a comment, we'll look into it. That is the then
Open instruction. File an affidavit.
That's all the first
the
15 is
grievance
also
of the petitioner is that petitioners or petitioner
petitioner.
that his name was recommended by the district level scrutiny committee. Now, what you say?
Level committee for compassionate.
District level committee for compassionate appointment by its recommendation dated
17/7/2007.
17/7/2017 showing definite vacancy, definite and available vacancies earmarked for appointment under scheme of compassionate appointment. However, the state level committee by under its decision dated
The dated Lordship 27/11/2020.
27/11/2020 rejected the claim of the petitioner on the ground that there is no vacancy. In view of the aforesaid, the respondents are to file an affidavit verifying whether the position of the DLC is correct or the stand taken by the SLC is correct. SLC is correct with supporting material. The learned counsel representing the state level SLC grace for an is granted 2 weeks time to file affidavit. 3 weeks time to file affidavit incorporating their stand, including whether including under on what basis the state level committee has concluded that there is no vacancy in spite of recommendation by the district level committee against definite vacancies. Please this matter list accordingly.
Obliged.
Due time, file a reply.
You want to file reply?
Lordship, one thing I want to point out
Yes.
for me, filed a appeal before the appellate authority, and that appeal have already been disposed of by the order 12/9/2023. We have already
This is challenge to what?
order of the disciplinary authority
Imposing punishment. Then no appeal preferred.
Then he preferred the appeal before the appellate authority, which have been already disposed.
Allowed or dismissed.
They upheld the decision of the disciplinary.
Okay.
So instructors already.
Now what is the you have prayer here?
I have a big on behalf of the product.
No, that may be.
We have already annexed that order, Lordship.
Already filed by the quick time.
Lordship will find that order at page 92 of the affidavit.
Pick up the witness.
Yes.
That is some of it.
Okay. On the prayer of the learned counsel for the petitioner, matter says adjourned and be listed for next Monday.
Obliged.
Yes, sir. Yeah.
Well, matter pertains to non-regulation service of petitioner. The Lordship kindly have a look at order dated 10/11/2020.
11/10.
2020. That's the quarter was passed.
Yes, yes. Who will bring the instruction?
Yes, my lord, I have sent a letter. This is to come from the PWD, my lord, from the government, my lord. This demands of they have forwarded, my lord, one proposal. My lord.
So you will have to give instruction whether you are considering or whether that can be done. That is, it's a regulation proposal for executive engineer Haflong on 29/7/2023 to the commissioner and secretary of the department.
Yes, my lord.
Now commissioner and secretary
Secretary will
apprise
give
us
me- yes, so
when?
my lord, let the matter come after 2 weeks, my lord. I will get the instruction.
This should go. All these burdens should go. Either you said he is not entitled, or you say that we are considering doing it within a period of such. Moment you say not entitled, we will examine. If you say that yes, we are examining, we can do it within a such period.
Exactly. So, my lord, I have to take the
For that, no 2 weeks is required. First stage will. And when you are here, even you can have over telephone. What is happening? People are full of hope. We do not know we can redress their hope because it should be supported by law. But since their name is sent, is expecting, you take a call.
My lord, let the matter come up on 16th.
16. Mr. Dot, learned standing counsel for the PWD, submits that he may be granted time till 16th.
December 2.
16th of December.
My lord, I just was wrong, my lord. I mean,
You remove that. Give the new one. I think. Then Dhar will compel us to come on a setter.
No, my lord, this is the new one. So I,
That's the typical. On 5 to 18th of December 2023 to obtain the instruction in terms of his court's order dated 11/10/2022. If the prayer is allowed, please record it. Have that.
My lord, cater of Assam Financial and page 7.
You want promotion?
My lord, not promotion. We want that TPC to be here. My lord,
You want a consideration? Consider.
my lord,
affidavit that we
there
have found that, my lord, there is no vacancy as such.
no, it's not. Page 37.
Page 37.
Page 30.
If no vacancy, I think you'll get something, some assured career.
Actually, my lord, one
This is
petitioner is
not
going to
the case.
retire by December this year.
Kindly
Okay.
see page 37.
Okay, page 37. Yes.
The additional secretary post is two.
Additional secretary paid for 2.
Both the posts are vacant. If from the director, promotion will be held in.
You
additional-
are a director.
No, I am senior financial advisor. If this post, additional secretary post be filled up
From the director.
from the director, then director's post will be arise two posts.
So,
So in the post of director, my case will be considered. And this DPC was not held from 2021.
now
Consequently,
tell us when this, according to you, stagnation is
Yes.
You are in the queue. So middle line should be cleared.
Yes.
So you are taking the cause of the director.
and kindly see their affidavit. Sir. Their affidavit, this process was initiated in 2022.
Hmm.
Kindly see page affidavit page 76 running.
Now these two directors do not want to be additional
Yes,
secretary.
this is the case, main case.
But what to do?
My lord, kindly see page.
If they are having no grievance,
No, kindly see page 76.
can
Why-
we say that
it
no,
is-
no, you promote them to clear his? We can say that. Can we say that? You promote them.
No, I am not saying that for promote them. I am saying that the DPC is to be held
Help for
as per rule 11 of the rule. As per rule 11.
what is rule 11?
Yes. Kindly see page. I have annexed the entire rule, my lord. Page 20 of my.
Rule 11.
Yes, rule 11 and 30.
What it says?
Page 20, my lord.
Hmm.
Appointment by promotion in the cadre shall be made in the manner provided herein.
Hmm.
Before the end of each year, the appointing authority shall make an assessment of number of vacancies occurred or likely to be occurred for filling up of promotion in the next year in each cadre, subject to suitability as may be decided by the board and by appointing authority and officer belonging to senior grade 1, senior grade 2, I am senior grade, junior grade 1 and junior grade 2 in Assam Financial Service and possession the qualification as set forth herein below shall be promoted to the cadre of selection grade, senior grade 1, senior grade 2 and junior grade 1 as below in the manner provided in rule 13 and 14. So from senior grade to selection grade, senior grade to senior grade, grade 2 to
Understand. According to you, sum and substance is that every year they will have to
Yes.
hold a DPC
Dip-
for all promoters.
All
They are not doing because that's why I'm in a
I'm
stagnation.
in a
Yes,
stagnant.
yes.
This is my
What is your case, Mr. Gogoi?
Well, here we have filed a affidavit.
Hmm.
The affidavit we have shown my lord the vacancy position as well as the main in position in the post of senior grade 1.
But how will you
Yes,
answer
that
his
also-
other that as a whole you will have to do? If we are not clearing the first door, opening, there is no scope of
That's why, my lord.
second.
Why we could not hold it, my lord? There, page
Where?
60, page 60, running page 60 of the
Okay, what it
court
says?
record. There is, my lord, para 4. As per the Assam Finance Service Rule 2019, the cadre strength of AFS, Assam Financial Service, selection grade, additional secretary, and AFS senior grade 1, director is given below.
Hmm.
Two additional secretary, two posts, two vacant, my lord. Senior grade 1, my lord, 4, main in position 4. A petitioner wants that, my lord, this particular,
Two should go to the
To the
upper
upper, yes.
level. Then there are two vacancies.
yes, then lottery
Then
vacancy,
he, according to him, it
then
should go.
he may go. Otherwise,
I
case will be considered.
am not saying that my consideration would come automatically.
Are you within the zone of, suppose we
Yes.
assume for the
Yes,
moment that
I one and number 1, number 2 has. I'm with the, then I will come under. No.
Suppose tomorrow if there is a we say that okay, this is you do it. But even then, if you are not within the zone of consideration, why should it?
It is statement I have given. I am petitioner number 1 is in cell number 1 in the gradation.
May I
Petitioner
continue
number
further?
2 is
May I
in
continue further?
Ah.
The feeder cadre of AFS selection grade is AFS senior grade 1. The name of the officers and the date of joining in AFS senior grade 1 is given below. These are the 4 main positions that are posted.
They are directors now.
They are at the level of director.
Directors now.
Serial number 1, my lord, he joined in 2019. Next is in 2021, and the other two of 2023. Now, my lord, page 21. Page 21 of the repetition part of the rule. 11(2)(a).
Page 20, page 21.
21. 2A.
2A. 2A.
That a member of senior grade 1 has rendered at least 2 years of continuous service as senior grade 1 officer for promotion to the cadre of selection grade. Now, Lottie will kindly see my lord page 61 again. Here only a person as serial number 1 is otherwise eligible. He has completed 2 years. This my lord person, second one, he has joined in 2021. Now, after rendering 2 years, this case can be considered after January 24.
not 24.
21,
calendar year.
23.
January 21, January 22, January 23. 23.
Now, may I read further? As per Rule 11(2)(a) of the Assam Financial Service Rule 2019, a member of AFS senior grade 1 became eligible for promotion to the AFS selection grade after rendering at least 2 years of continuous service as senior grade officer on first day of January of the year in which selection is to be made. 3. P.K. Saki, AFS Director, a Director of Audit, Local Fund, has completed 2 years of AFS senior grade 1 and became eligible for promotion to AFS selection grade with effect from 1/1/2022. However, a complaint of sexual harassment was received against him when he was serving as Director of Pension. He was kept on compulsory waiting from 19/12/2022, 24th and 2021. The internal complaint committee chaired by the Secretary to the Government of Assam Finance Department has found him guilty. A penalty of rupees 10,000 was to be paid to one of the complainants. Has been
so his promotion is also ruled out.
Next, my lord, the Devojit Nath, the person is serial number 2. AFS has joined as director on 8/1/2021 and he has not completed 2 years in that post as on 1/1/23. As per Rule 11(2)(a) of the Assam Finance Service Rules 2019, he will be eligible for promotion with effect from 1/1/2024.
When this petition was filed?
There are no other officers in the cadre of AFS senior grade 1 director who will be considered for promotion to AFS selection grade. All gazetted officers are supposed to submit their SCRs and APRs on time. Due to non-receipt of ACR and APR, letter has been received by memo dated 18/7/23 to 3 P.K. Saki and Devojit Nath so to submit their ACR and APRs annual property report. Accordingly, ACRs and APRs have been received on 29/7/23 and 2/8/23. The ACRs have been processed for recording, reviewing, and accepting by the concerned authority as indicated below. These are the authority matters we will have to consider till finally accepting the ACR. Next, para 4. The deponent begs to rely on para 4 of the incident affidavit and reiterate that ACRs and APRs have been received from the concerned officers and under process of for recording, reviewing, and accepting. Once the process is completed, steps will be taken to hold a meeting of selection board to consider the promotion to the post of AFS selection grade. The composition of selection
Where is
board.
that? Where is that?
Para 5. Page 64. Once the process is completed, steps will be taken to hold a meeting of selection board to consider the promotion to the post of AFS selection grade.
When have you entered the service, this service? You entered? When have you entered? And they have taken a stand, they will do it. What,
Only-
how
only
much
when
time will
Only
you?
the
Petitioner number one
is going to be retired in this.
For that cannot be, my lord, that will have
Otherwise,
to
if it is
hold the, my
quali-
lord,
if one post considered, then also petitioner's name will come because he is in number one.
Yet we cannot impose that you do in a these days. There are problems.
My lord, kindly
the
see one,
procedure of
There are
considering
some
the APRs
judgments also
and
very.
APRs are
one
not
annexer, my lord, they have annexed. Kindly see page 7. They are not doing intentionally from 2022.
What we have come a little bit, because you have
Page
also you
76.
have become qualified in the month of January.
No.
January 23.
No, I have qualified. Right. I have already qualified.
Then you have filed a petition in 2023.
My lord, kindly see page
Because
7.
your other bogey was not
Because at that
matured.
point of time it was not
Huh.
vacant. Page 76.
Hmm.
This letter of July 2022.
Hmm.
With reference to subject cited above, I am directed to request you to kindly submit the SCR APR as required so that them can be placed before the DPC for promotion to the cadre of selection grade under Assam Financial. Since July 2022, they are not submitting SCR, and on this pretext, selection was
Now, what
Well-
kind of direction you want?
my only that the selection consider the selection process.
Now, suppose then they will have to be removed. Without upper, they will have to be, suppose they are not giving upper, they do not want from. Tell us what kind of order read we can issue in such a situation.
My case is only for consider that selection
By when?
by this calendar month because it was already over in 2023 first January.
Now, suppose they are not giving. We will have to pass a direction to Prithvish Kumar Saki and Revojyoti Nath.
they are
That
not
you
party
will have,
and
you are bound to give your upper and STR. They are not parties.
they are not.
No, they are not.
Now you give me a.
Only consideration for holding the tip. Nothing else.
No, they have said that what is their problem? These people are not
No,
giving.
no. In paragraph 5, they are saying that they are holding the tip. Only to expedite that tip.
Okay,
That
they are now
they are-
in the
they are
meantime they
saying
have
that-
given.
In
No,
the meantime, they have given.
They have given, but this process for considering the, my lord, ACR, that is, it will have to go to the, my lord,
When they have given it.
recording authority, reviewing authority, then accepting authority. So this process is on.
Hmm.
Yet to be completed.
When you expect to be completed?
That, my lord, without. I cannot
Suppose
say,
his
because
name is also could be under consideration.
With respect,
See,
my lord, this
people
case
are
can be
having.
considered, my lord, only when there is a vacancy.
Ah,
First, DPC will be held for this particular post.
Post.
Only thereafter, my lord, next step will be taken.
whether they are promoted
Yes.
or not promoted.
In anticipation, my
Can
lord,
we
DPC
direct
cannot
all this to be done within a month?
my lord, and this paragraph 5,
No, kindness is different thing and judicially reviewable things is two different things.
my lord,
One is
to
kindness.
expedite that process.
Expedite, we can say, we do not want to pass and read or issue a read which is having no meaning. We'll say we consider you expedite within a month. They will come and say, no, we could not do it because of this. We are helpless.
My lord, so far petitioner number 2.
We will pass an order where we can get hold of them that yes, we have not done our.
They have not done. They have not done.
No,
It is
our order. We are concerned with our order. We pass an issue a read. It must be enforceable. Non-enforceable, consider, do this. I am not student.
My lord, kindly see my prayer. Which prayer I have made. Kindly see my prayer.
That order we can pass, but it's difficult
A
that it
writ
should
of
be within a month.
Directing the
Within a
respondent
month will be a difficult
to
proposition.
fill up the 2 vacant posts of selection grade.
Many people retire like that only. It's a part of your service. If your higher authorities, your vacancies are not there, consideration is a futile exercise.
No, if
Isn't it?
first it to be clear.
First is to be clear.
Yeah.
So for you, there is no vacancy.
There is vacancy, 2 vacancies.
Two vacancies, but
2 posts is
No,
not.
no. Where is the vacancy?
no, there is no vacancy. First, other grade 1, na?
Yes. From
selection
grade one to
selection
selection
grade. Now the selection grade is to be promoted to the additional.
No.
From grade 1 to
From-
selection
No.
grade, and they are grade 2, they will be
They'll
then
be grade
in their
1.
vacancy, they will be.
So that's what. So
Selection
for
grade
you, there is no vacancy as such. Your vacancy is
will occur
dependent,
when the selection grade will be filled up.
filled up.
Yeah.
Now select, can we say that no, you'll have to complete selection grade within a
my lord,
month,
selection
then
grade, yes,
your
yes.
promotion.
And notice
Yeah.
this before the honorable
It-
court
it
saying
should
that
be-
they should be promoted to selection.
No.
My lord, it is simultaneous. Rule 11 kindly all the promotion. Kindly see rule
Okay,
11.
understand that all the posts will be
all
and
the
for anticipated vacancy also.
Yes.
Okay, anticipated vacancy they can do.
11, rule 11.
I have seen that. All the vacancy.
It is not that only for selection grade it be held. It to be held for all. Anticipated vacancy, rule 11(1) also.
Go have an instruction
My lord,
by weekend. Within which period you can do it?
by Friday.
By Friday or Monday?
Early
Friday.
people.
Friday.
It's Friday.
Friday
Because
you have it.
Only on that part,
Everybody is
my
having
lord.
aspirations. If others who are not interested to go to the additional chief secretary, what can we do? Now they have given. It will also take time. Many things
My
are
lord,
there. It's
we will
not
kindly
like
see
that.
the annexure,
Now
my
we
lord.
understand. You not like that. You will just have held
No, the
it.
petition ought to have come early, my lord. Torsi will see page, my lord, 77.
No, that we understand.
77, my lord, the ACRs were submitted on
Because
July,
the
my lord.
other two persons,
No, in
this
July 23, the
directorship is,
ACRs
I
were
think
submitted.
it's, he also want to be the director. And the other person, they do not want to be promoted to the higher grade. Problem is there. Because the most lucrative post is the director's post.
I am going, my consideration, I am going to be retired in December. I just want at least second and
That is what I have
go to one
worked so
promotion.
hard. If I do not become a director, at least after retirement, he can say that I retired as a director.
That much,
That
nothing
much.
else.
So do something. Friday.
Friday.
Mr. D. Gogoi Lanet, standing counsel for the Finance Department, shall apprise this court regarding the time schedule within which the promotion that has already been process of promotion that has been initiated can be completed, inasmuch as the learned counsel for the petitioner has expressed an urgency that the petitioner number one is going to retire within is going to retire on 31st of December 2020. So give him for 15-20 days.
So for petitioner number 2, he will get the benefit. There will be no
26 is going to retire.
That he will get.
He will get.
Otherwise, somebody will retire in the higher up. Yes.
Wait, please, my lord.
Yes.
On the last occasion on 8/9/23.
My lord, we are yet to file our affidavit in this. This is regularization. Then it.
What does you want?
My lord, I'm seeking for regularization. I was appointed as a work charge section assistant since the year 1994, my lord. And pursuant to this, we had filed a representation to consider a case for regularization, which they had not considered. And that constrained us to approach the Honorable Court. And my lord, by the order dated 21/9/2018, WPC 3469 of 2015, the Honorable Court, in light of an OM dated of the year 2013, directed the respondents to consider the case of the petitioner, saying that he is otherwise eligible given the consideration of the terms and conditions of the OM. And it was directed that the respondent authority should consider my case within 3 months. However, that was not done, my lord. After that, I had submitted a representation in the year 2023, which they have not acted upon. As such, I have approached this Honorable Court again by way of this writ petition. And my lord, there are 2 vacant posts under the establishment under which I am working. And I am apprehensive that in the meantime, that those may be filled up. And there has been no response from them, my lord. Hence, I had also sought from interim order that at least 1 post should be reserved until the pendency of this petition or till the time to consider my representation.
Regularization is not against post.
Yes,
They will create if necessary, a personnel post. So where is the question of keeping a post vacant? Regularization, we can give a direction to even if permissible under law, even for creating a post. So why should a post be blocked?
I am not pressing on that prayer, my lord. However, my
if
lord,
you are not pressing, don't press. After pressing it being rejected, You say I'm not pressing. That is a rejection.
That
Not
was
pressing.
one of the interim periods I thought. Matter, they were supposed to obtain instruction. Perhaps they may file their affidavit on this matter. It's a long pending matter, my lord. It's a 23 matter. No, there was a previous writ petition,
No,
my
no,
lord.
do one thing. Why you have to keep all this pending? Court has passed an order, consider.
Yeah.
Consider if they are entitled, entitled, not entitled, not entitled.
Not passed no order to take.
And how a writ petition is maintainable?
My lord, the honorable court has recognized that we might have a claim in right of the OM.
That has already been directed to be considered.
Which
They have
have
violated
considered.
the order. File a contempt.
My lord, there is some
So
apprehension.
one year is gone.
I
Or
don't-
what?
3 years.
No. Contempt. Contempt.
My
period.
18 order minority, they have filed their representative in 23 before the possibility. So
Do
they are
this,
also sleeping with their
My lord,
order.
So you also
5
sleep.
years.
Okay, when Mr. Dhar Learned Counsel for the respondent submits that he may be granted some time to obtain instruction on the action taken by the respondent authorities for compliance of
my lord, for order dated 21/9/2018.
21/9/2018 passed in WPC
3469
3469/2015 and the representation of the petitioners dated
dated
17
17/7/2023.
77
2023.
My lord, to fix the date.
January.
My lord, in between,
First week of
We- we
January, my
have-
lord, any date.
This method January.
I'm so obliged.
court, my lord,
You will have to do your exercise before 22nd. Fixing 22nd and 4th is same thing. You will, of course, will not work and call these officers during vacation. We do not want you to do that also. Yes, next.
I'm obliged.
Yes.
Relating to appointment of Gaupara of number 8 is Pokemon update.
Hmm.
That other evidence tackle the Nogadi.
Now Gaon Buras and become Pradhan. Or what? Or
yes, my lord, now they are processed.
or Pradhan.
They
In
also-
Assam or in other Arunachal and Nagaland, also.
Nagaland, it is still Gaura.
They will. They know how to keep
Yes.
their tradition.
Expected is that for your honor. By the duty check.
Hmm.
But the respondent has not appointment letter till date. About 1 year already.
I have inspection. My lord, there was public complaint against him.
Hmm.
So that's why it is withheld, my lord. His thing, my lord, appointment. My lord,
Now, why don't you allow the public to take over your administration?
no.
There is yes, public is having a value in a selection of Gaon Pradhan. But that value is to be given and weighted in terms of the rule
The rules,
prior to selection process. Isn't it? The rule specifically provides that what should be the procedure, opinion of these mujadars and these, that. After taking that, you made a selection. Some extra constitutional authority will come that, no, this is not handsome, we do not want. So that is a public will. Better you allow the people to directly run the government. No people's representative is required. No deputy commissioner is required. Isn't it?
my lord, say direct the deputy commissioner holding inquiry, my lord. This complaint and pass an order.
Not already 1 year lost.
Do you have a right to get appointment after selection? They may very well cancel. After appointment, we can understand that on the basis of public complaint, you cannot be removed. But your right has not yet come. They may cancel, no, we committed a mistake. These are bogus appeal. Absolute bogus. He is having a loan. So how can Baki Vijay certificate be given? But loan is something different. Baki Vijay certificate is given. That is any.
Yeah.
Where is the rule? Appointment rule. Gaon Pradhan.
Rule is there. Just have it.
Okay, okay, okay. Heard Mr. DC Bora Learned Counsel for the petition. Also heard Mr. R. Dot Learned Counsel representing respondent number.
The
Mr.
rest
J.
man.
Hendik for one and Mr. Thor for
All other man.
remaining respondent. Good stuff.
20.
The present petition is where is your appointment selection?
It's 20. 29. Field number 4. 29. Date of birth. Doctor. Date is project 5 of date of date.
What is 31?
There are 7 selection lists. And all of 7 number of revenue.
Okay. Pursuant to a selection, pursuant to an advertisement. Where is that advertisement? Dated 29/2021. Huh? 20/09/2021. Yes, Mr. Counsel.
Annexure 2.
Tell us the date.
Page 4.
Tell us the date. Huh? 29. 20/09/2021. Pursuant to an advertisement dated 20/09/2021 for filling up the post of 82 numbers of vacant posts of Gaon Pradhan under different revenue circles under Nagaon district, the petitioner was selected as, where is your 26? 29. The petitioner was selected for appointment for the post of Village Pradhan against number 8 Niz Paki Moria village. It is the grievance of the petitioner that, in spite of such selection, the petitioner has not been appointed till date. This court, under its order dated 29/9/2023, 29/9/2023, while issuing notice of motion this court, under its order dated 29/9/2023, issued notice of motion. Mr. Dhar has obtained an instruction to the effect that there was a public complaint against the petitioner. Complaint by public. There is a public complaint against the petitioner, and therefore his appointment order has not been issued. Even if it is assumed that there is a public complaint against the petitioner, a selected candidate, candidature of a selected candidate cannot be rejected in the manner it is sought to be rejected, that too without hearing the petitioner on this issue. Full stop. The complaint received is also produced before this court, which discloses that some persons, 27 in numbers, has filed a complaint before the deputy commissioner requesting him not to inquire into the matter and appoint some other person in place of the petitioner as Gao Pradhan. The said complaint neither disclosed who are this identity of this person nor any substantive materials are annexed with such complaint. Be that as it may, it is in view of the aforesaid factum, it is directed that the respondent deputy commissioner shall take a call upon the complaint filed by the aforesaid 27 persons on 21/9/2022 before him and take a decision on the entitlement of the petitioner for an order of appointment. While completing such exercise, the deputy commissioner shall take note that such complaint that in such complaint the complainant has not disclosed their identity, their residence, etc. And no substance, though there are some allegations are made, such complaint is not substantiated by any of such allegations. Accordingly, the present petition is disposed of. The entire exercise to be carried out within a period of 1 month from receipt of a certified copy of the order. The deputy commissioner shall also take note that except the complaint, there is no other material to withdraw the selection of the petitioner, inasmuch as there is no allegation that the selection process has been vitiated by any fraud or that the petitioner has withdrawn certain necessary disclosure. This is not the way.
May I please the matter pertains to compensation appointment. The matter, the name has been placed for the district level committee matter, page 31 matter. Sorry,
Yes,
matter,
yes.
page 42 matter, page 42.
DLC rejected or recommended?
DLC rejected my lord due to want of vacancy. Page 42, his name is
Now, what is your grievance? If want of vacancies there, what kind of order can we pass?
posted 115. If the concerned department there is no vacancy, then the department can refer the matter to any other department. Have annexed the matter.
When your rejection was done?
Rejection was done on 2019, man.
2019.
It's 28 February.
And this waiting list will be for unlimited period or what? Yes, when we fix that matter, morning, not a thing. Compassionate appointment. Huh? 7/12. List this matter on 7/12/2023 along with item number 6. Yes.
Lordship, in this matter, we had appeared for the first time in the last petition, and notices we had made us party for the first time on the last petition. Lordship, we have already written to the department, Lordship. We
What
are
is
awaiting
this
our
case?
instruction.
To rectify the appropriate date for.
Okay. The learned counsel for the respondent number
1.
1 prays that he may be granted some more time to obtain instruction in this matter and file affidavit if to advise. Prayer is allowed. You are getting your salary with the reduced amount. Please this matter. When? Oh, why we are looking at her page? You tell us you are taking adjournment.
Lordship, immediately after the reopening.
Okay. Court.
DP.
You are praying for an adjournment. What is this matter?
Getting the termination.
Huh?
Termination.
You have been terminated. You want some time? Some time. Why? Okay. It's submitted that Mr. Who will appear? SK Talukdar, learned counsel, appearing for the petitioner is having some personal difficulty. Okay. Accordingly, a prayer for adjournment is made. So the prayer is allowed. Please this matter. No, any date is difficult. Please this matter after 2 weeks. Just a minute. Yes. Yes. Bhagavati.
Out of 20 lakhs, 84,000 odd amount, my lord, we paid 10 lakh 55,000.
Which transport?
Transport. It's Assam State. The only thing is we are waiting for the budget. Let it be after vacation, my lord. The meantime, it may happen to that budget.
Not happen. She'll have to give a commitment.
I cannot give my lord.
Have your instruction. No, yeah, otherwise you are closing down.
Not closing down. It's reviving, man.
Reviving still.
Reviving. Yes. We have done some good job, my lord. And we are getting the payment from ONGC and all that because we have hired the vehicle there also.
Okay.
So we are.
How much is remaining?
10 lakh.
Salary.
No, retirement benefit. 10 lakh 29,300.
What was the total?
Total is 20 lakh 84,700.
50% you have paid.
We have paid. And budget comes, my lord.
Budget will come in the month of March.
No, my lord. There is an interim budget also, my lord.
Okay.
We are waiting.
Supplementary budget. Huh? Supplementary. December. Okay, you have it. Mr. J. Roy Larned, Senior Counsel, assisted by El Ahmad, submits that the corporation is not in a good financial condition and therefore they had sought a supplementary budget for payment of pensionary benefit to their retired employees. And therefore, all likelihood they will be in a position to make certain payments to their retired employees in the month of January. Accordingly, he prays that matter may be adjourned and be listed in the month of January, 10th of January. Open. 10th of January 2023, on which date Mr. Roy shall
Please the inspector.
obtain place the instruction.
Right.
Yes.
Poor employee, he is working in the education department.
Okay.
Order came in his paper way back in 2005. Lordship benefit was given to somebody else, their lordship, with the same name. He recorded a petition. First writ petition, WPC 4381 of 2013. The lordship will find it page 17. Details are given here. My details.
Yes, what you say?
Second writ petition was filed. That has been violated, my lord. Lordship, this writ petition, this contempt application was filed in 2022 in the month of July. So the subsequent plea of them is that they are preferring review applications against two applications wherein two orders have been passed in my favor, my lord. So those two review applications have already been dismissed by this.
That has been dismissed in 30th of October, Lordship. In the month of October, there was a
Now we are in month of December.
Now, Lordship, we are in the process of regularization.
In fact, Lordship, I personally instructed my officer to Lordship to send the fence proposal of to the finance part
for the
regular process pension proposal.
When will you fix this matter?
Lordship,
But we will not hear this repeat this present that we are doing.
In fact, Lordship, initially we have sent for pension proposal to the finance department.
What pension were you working, my lord?
Finance department, Lordship, came for Lordship review petition.
No, this is a working.
Sorry, Lordship.
Not pension. Not pension. Area. Now, are you getting current salary?
Nothing. Even my wages have been stopped. And the last occasion when the matter came up, your lordship, they have taken longer date with the pretext that they'll consider my case. Nothing has been done as on date, my lord.
Who is this contempt?
Irrigation department officers as well finance department. Actually, the main anomaly has been committed by the irrigation department. Finance department. Irrigation.
Okay.
Benefit has been given to somebody else with the same name, Bhugondas.
Lordship,
In between that Chandra part is not there. Benefit was given. That person has already been retired, my lord. Getting the benefit.
I have already submitted my report, Lordship, in the record probably, Lordship. It is not there, Lordship. I am submitting again.
Keep it.
Lord. After this,
Lordship, may I pray in this matter, contempt proceedings withdraw.
We are interested in paying them.
My senior client is getting benefit. That is not.
Where, my lord?
He is getting relief. This is the status, Lordship. Thereafter, in the meantime, Lordship, after that, Lordship, they came, the finance department came, filed the review petition.
Now, what do you say? What is your submission?
Now, Lordship, we have to submit the first proposals to the finance department.
But within which date you will submit the first proposal?
2 weeks, Lordship. I have already instructed.
We'll fix it 2 weeks, no problem on that. We want a specific schedule.
Yes.
That you will send a proposal on within such and such date. That proposal, finance will do complete their exercise within this period, and thereafter it will be within this, at least to that you need an assurance. You have instruction.
My instruction is, Lordship, file have already been moved, Lordship. It is
movement may be faster movement, slower movement. We are not happy with the movement. We want to know. We are fixing this method. Day after tomorrow, Wednesday, you both have your instruction, concrete instruction. Will record the months or dates that within this period proposal will be sent by so and so to so and so. Thereafter, he will take this much of time to complete it and send it to finance. Finance will do complete this within this period, and then we'll fix the matter on that date with an up-to-date. Friday.
Lordship, in the meantime, although Lordship
in the meantime, what?
Nothing, no wages, nothing. How done? Myself, my lord.
You wait for Friday. I am with you.
Yes.
I am also with
everybody is with you except the officers.
Yes, we will have client only.
Everybody is with you. So on Friday, Mr. You do it. Because we are not recording anything, but we are fixing it for further instruction. Please this matter on Friday for instruction regarding with a up-to-date status regarding payment due to the petitioner.
Regularization.
Everything.
Yes. Lordship, it's
regarding
Lord.
this
Partner, my lord,
contempt
kindly.
cannot be partner. What
Kindly,
are
my
you
lord.
saying? You are senior counsel. Yes. Uh, regarding the status of compliance of order dated,
There are two orders, my lord.
compliance of
Subsequent
orders
order,
dated
which I have filed contempt, 27/10/2021,
and
passed in WPC 5643/2021.
one
The earlier order
and
is
and
22/2/2019,
19
passed in WPC 4381/2013.
list according.
Always.
Or if necessary, we have our links. Give to your officers.
We'll get
If
the
you
info.
cannot convince, we know how to get the work done.
We'll get the info.
Yes. Sharma.
Yes, my lord. Certain incumbent in the office of the engineer have been recently impeded. Please
You want
take notice upon my lord, the present chief engineer, Mr. Dipojoti Duora.
you are appearing for the respondent.
Petition.
Petitioner. Now what today's your prayer is?
There is for my lord payment of
No, understand, but who represents notices are served?
notice two already start.
Who is representing two? Name shown. Anybody appears?
Name was Dubey.
Where is Dubey? Name shown.
Name shown, man.
Huh? Item number?
Item number 46.
What's the name?
Other name is
Item
earlier
46.
Dubey appeared.
Item number
46.
46.
Earlier Dubey appeared.
Now A and I Hussein R2. Who is R2?
R2 is my lord Ramajoti Sharma.
Where is the order?
Implement. Implement order is my lord.
No, not implement. I want the order which you allege that is violent.
Order of the honorable court, my lord. That page
It's
11.
12.
Page 11. Last page 13. Page 13. There is a direction to page 13. Mark.
Pension.
Not paid till it. No provisional pension has been paid.
Sir, who is pension? Whose department? Forget about the person.
My lord, public health engineering.
Which space is standing at? Yes.
I applied for setting of it, but we have not received it.
Okay, not necessary. We will give you the handle. You go to give a copy to him.
Right.
It's a pensionary benefit under Sanchita Rai.
Yes.
Then Sanchita Rai was challenged also. Then it was upheld with an additional ground that not only everybody will get it. Anyway, now you will have to give a copy to him. Who is the present secretary or who will do this? Who will send your proposal?
Well, the proposal has already been sent. Lordship may kindly see.
Sent to whom?
By the executive engineer to the chief engineer, my lord. Thereafter, my lord, to the principal accountant general. Again, that was returned by the accountant general to the chief engineer. Since then, that matter is pending. 21.
Where is that?
Lordship may kindly see that is 18, page 18.
The present contempt petition is filed alleging non-compliance of order dated
11/12/2020.
11/12/2020 passed by this court in
My lord, 7022/15.
in WPC 7022/2015. Full stop. In terms of the aforesaid order, in terms of the aforesaid decision, the petitioner is entitled for pension, regular pension. Full stop. The aforesaid order was passed relying on a decision of this court in Sansita Roy reported in Pension, and it was held that case of the petitioner is covered under the determination made in Sansita Roy Supra. Okay, so Sansita Roy citation. Sansita. Full stop. From the material, it is seen that where is that proposal?
Proposal is page 16.
The pension proposal in terms of the aforesaid judgment was forwarded by the executive engineer to executive engineer Hosai division Hosai. The pension papers of the petitioner were forwarded by the executive engineer Hosai division Hosai to the chief engineer PHC Water Resource Department along with required documents. Subsequently, the matter reached up to the principal accountant general within bracket A and E, and thereafter the principal accountant general A and E returned the proposal pension proposal. Where is the return?
My lord, 18. Page.
It returned the pension proposal, raising certain objection regarding fixation of pay, etc. However, etc. by its communication dated
5/10/2020.
5/10/2021. However, till date, the petitioner has not received any pension and or her or his pension has been finalized. Though this is a matter pertaining contempt, however, considering the fact that it involves the payment of pension to a retired employee, this court has sought assistance from Mr. I. Bothakur, Learned Standing Counsel of the Public Health Engineering Department. Requested Mr. Spencer, requested in the theater method, this court PHC department, which Mr. Bothakur has readily accepted such a request and ascertains this court that he will obtain instruction regarding the status of compliance of the order as discussed herein above and regarding the status of the pension proposal of the petition. Accordingly, Mr. Sharma, J. Sharma shall give an extra copy of this petition along with a contempt petition along with the annexures to Mr. Bothakur to obtain the necessary instruction. Obtain the necessary instruction. Accordingly, matter is adjourned and be listed on next week.
After week.
No, after week. The pension. How a people is. We are going out of the board. It's a pension. Everybody should be sensitive. Yes. 14th of December 2023, on which date the Departmental Secretary shall apprise this court through the Learned Standing Council regarding status of the compliance of the aforesaid order and payment of pensionary benefit to the registry to list this matter showing name of Mr. I. Thakur as in the court. Yes. Yes, what is this? What is the order? Page? Yes.
Lordship, here I appear for the PCCS. There's an office letter to the Additional Chief Secretary at Forest Department where the DFO has been asked to take this matter up with the Accountant General.
When?
This was done, Lordship, in 3rd August 2023. After that, Lordship, the report has not been submitted yet. The action taken is.
So let both of them be here.
I have an instruction.
Yes. Tell us the stuff. Contempt, be serious in this place, in this court. Oh, which part is not given?
What's the interest part? The first was done long back, but
Oh, this case, I passed this order. Imposition of interest. Still you are behaving like this only. So double the interest, still payment. 12%.
Perhaps if the DFO is impleted, we might get the updated.
No, we will not implicate anybody. It's a contempt between us and your officer. Let the officer, your PCC be present here.
Lordship may give me one opportunity.
Wednesday.
Yes.
Give the status. You are appearing for?
Forest,
Response number?
PCCS,
Response-
1.
The learned council, Mr. I. Thakur, learned council appearing respondent number 1 submits that he may be granted some time to get the updated instructions regarding payment of interest in terms of payment of interest to the petitioner in terms of the order of this court dated 10/6/2022 passed in WPC 5420/2022 to establish this matter on Friday. An indication that if there is further delay from the salary of the person concerned at whose for whom there is a delay. Just send this message. You take your instruction.
Alright.
Okay. Teacher. Okay. Yeah. Yes.
It has been applied.
Mr. Deuri. Now, this is a corporation appointment.
Yes, sir.
Now, there is a direction. Now, where is the appointment? This is serial number 9.
Serial number.
Eligible for appointment, but due to lack of vacancy under IS Lakhimpur, the committee recommended and adjusted the candidate in grade 4 post under IS Golaghat. None appears for the petitioner on call. However, Mr. Deuri submits that the order dated. However, Mr. Deuri, learned counsel appearing for respondent number
Deputy
to Respondent number, appearing for the Deputy Commissioner,
Not like
okay, North Lakhimpur, submits that the case of the petitioner, the name of the petitioner has already been recommended for appointment as a grade 4 post under Inspectors of School Golaghat, as there is no vacancy. There is no vacancy in under the Inspectors of School. Inspector of Schools, Lakhimpur. Lakhimpur. He also produced a recommendation. He has also produced a recommendation in this regard. Accordingly, the present contempt petition stands closed.
obliged.
You want to
No, I
okay.
That may be a part.
Come on, you got recommended. A copy of such recommendation is kept on record, marked and it's documented.
Obliged.
Yes. Yes, Sohan.
My lord, similar to other contempt petition, with this is my lord 6 on 6. Honorable Justice Montham has heard the matter.
Okay.
And it was 6 for this 6.
Okay.
So this is also tagged here, my lord. It will again come on 6.
Okay. It is submitted that similar contempt petition is fixed on
418 and 420.
senior contempt petitions being
418 and 420.
418 and 420. 418 and 418 2023 and 420 2023. No.
That one is 419.
This is 419.
Yes.
Okay. It is submitted at the bar that this court, under its order dated 29/11/2023, passed in contempt case number 418/2023, directed the aforesaid contempt case, within bracket, contempt case number 418/2023, to be listed along with present contempt petition on 6th of December 2023. Accordingly, the present application stands adjourned and be listed on 6th of April along with contempt petition number 418 of 2020. On 6th. Yes.
Entire appearance on behalf of the respondent number 1, Your Honor. 3 weeks time to place the instruction.
Yeah.
2 weeks.
Okay. The learned counsel for the respondent number
1, Your Honor.
1 and respondent number 2, grace for and is granted
2 weeks.
2 weeks time to file
Place the instruction.
to complete the instruction.
Oblige, Your Honor.
I have not taken the steps, but the Lordship, I have taken the steps today.
Okay. The learned counsel for the petitioner submits that the steps has been taken today itself. So, accordingly, steps for issuance of notice upon respondent have been taken today only. Registry to verify and list after 4 weeks. Yes. Who name shown? 52. No order has been passed yet or what? Oh, passed. Okay. Tell us, where is the order?
Order is 10 to 13.
What is the direction? Where is your submission of representation?
Representative submit on page 14 to 95.
When?
Submitted was 78. After
17.8. Then 6 months from 17.8,
not 6,
60 days. 17.8. 17.9. 17.10. Art. Islam. Learned Council for the present application is filed alleging willful violation of the order, willful violation of order dated 9/8/2023 passed by this court in WPC, passed in WPC 224 of 2023. There is the material. Full stop. Issue notice. Returnable at the court. Both ways, yes, both ways.
contempt matter after page
Huh?
17.
Yes, that's where is the order?
17. 11. Last. For the court is last but the correct. The petitioner is not for captain is not for have not given a job copy. There was not last matter because part of the hearing. Here was the third copy.
Okay, noted. That. Both ways, step both ways within 5 days. That's it.
Contract to fight back. After listener to 10 and article they are working at contract for 5. Now when the check period was to over 6 was take over, that is not this component of that protected by modern.
Okay, now any
Their private response is 5 and 6. Whether they have been served or not, they are the main approach.
where large? Okay, okay. In view of order dated 1/12/2023 passed by the passed in the proceeding of Lawajima Court, the notice this matter is ready as regards service. Mr. Gogoi, learned counsel for the respondent 1 to 4 praise for and is granted
4 weeks.
4 weeks.
Issue is pending for the
4 weeks time to file affidavit. The interim order passed earlier shall continue until further order. 57.
only I created 1 month copy may be served.
Okay.
Further
We need not pass an order, give a copy. Okay. So second also same. What is the issue here? Dismissed from service.
So the betting of the some criminal case method Portugal police station. That case method still that method no such has been filed. But
Okay, we'll take some other day. Not today may not be possible.
The date is fixed. Fixed on 4/1
Already.
by the last.
Oh, this was a 4/1. Why this has been replaced? Okay. That's why I think better to hear 4/1. Though matter has already been fixed on 4/1/2024 by this court under its order dated 30/11/2023. Matter has been listed today. Matter then adjourned and be listed in terms of the order passed on 30/11/2023 and on 4/1/2020.
Problem.
You could have said in the morning.
Thursday morning. I thought he was saying
From tomorrow, we'll first take motion, then we'll go to orders. No problem. Motion, just give a notice, then orders, then we'll go to admission. But admission takes time for this.